Judiciary Committee, I'm going to ask Dr. Watson if he'll open us up in a word of prayer.
Let's bow our heads. Dear Lord, thank you for looking over us, keep us safe in our travels, and continue to look over us and let us do your will and be very deliberate in our thoughts and deeds. In Christ's name I pray, amen.
Thank you for doing that. We have seven bills on the agenda for this evening. We also have multiple committees going, as you see, so some members may come and go. We'll try to keep a quorum and try to keep things moving as quickly as possible. As always, if you want to speak on a bill, please sign up on one of these sign-up sheets. If we missed you, please come up now and sign up to speak on a bill. We will start with the top of the agenda. Never mind. We will start with down the agenda, Senate Bill 185 with Senator Williams. Come on up and give the committee a chance to flip through their folders and find your bill. I show we're working off of LC 442270. Is that correct?
Yes, sir.
All right, the floor is yours.
Thank you, Mr. Chairman, members of the committee. This basically is a bill asking for help for our district attorneys all over the state of Georgia. And it specifically states when qualifications and compensation to provide for the appointment of additional assistant district attorneys in judicial circuits with multiple detention facilities. In the Okmulgee Circuit, which is in my district, main district of Baldwin, Hancock, Putnam, Jones, and Jasper, we have 5 detention facilities. We have Baldwin Prison, Geo Prison, Hancock State Prison, YDC, and the Cook Building forensic facility there with forensic prisoners in that one. Some of you may remember some of the things that have happened in our area. We had 2 prison guards that were hijacked and murdered in our area. We have murders that are occurring in the prisons, the gangs murdering each other, and crimes are being committed in the prisons. And what we have is a very large Okmulgee circuit with a very active criminal prosecutions going, but they need help. And that's what we're asking for. And I know that my district attorney, Wright Barksdale, is here, and I think he is signed up to testify, and maybe some others.
All right. Any questions for the author before we get to those that have signed up to speak? You have no questions, so if you want to sit tight, we'll bring up, and move back to the row behind you, we'll bring up the other people that are here to speak. First, we'll have Mr. Wright Barksdale, the district attorney for the Okmulgee Judicial Circuit.
Good afternoon.
Good afternoon. How are you?
I'm doing great.
Good.
I just want to start with, it's an honor to be here and to discuss this with you. I am the district attorney for the Okmulgee Judicial Circuit, and it's an 8-county circuit. It includes Morgan, Greene, Jasper, Putnam, Hancock, Jones, Baldwin, and Wilkinson counties. I was elected took office in January of 2021. I have, in the process of 2 years, tried and resolved, my office has tried and resolved 26 homicide cases. Of those, I myself prosecuted 10 of those as the district attorney. Not because I didn't have other things to do, but because I'm provided 7 state-paid ADAs to cover 8 counties. Since I took office, myself and my chief ADA, Allie Malden, who is here with me, we have spent 12 weeks total in the last 2 years trying 2 separate death penalty cases that came out of our prison system. It has, for a circuit my size with 7 state-paid attorneys, it has been a extreme cost of resources and manpower that, quite frankly, has probably put the people of my circuit at a disadvantage at times. I approached Senator Williams about the possibility of putting something together for your consideration, and this bill, I appreciate the work that he has done. I want to give you some additional perspective here. I have 22 pending murders in my circuit, and 8 of those come from the Department of Corrections. Now, that is just the murder cases. That does not include the assaults on officers, the assaults on other inmates, the gang activity. I had the opportunity last week, and I apologize for not being here last week, but I had the opportunity to look at and listen to Judge Stewart from the Atlantic Circuit come before you last week, and the very first thing that he said in requesting an additional judge was, our circuit has all these prisons in it, and we're having to field all of these prison cases. To put it in another light for you, Hancock County, Jasper County, and Wilkinson County have less than 10,000 people countywide. When you add up the population of the prisons that are in my circuit, it is basically the same population as one of my counties. So I submit to you that I don't have 8 counties, I've got 9 counties. We have done a study, and I'd like to thank some of my interns from the University of Georgia for putting together some documents as to how many positions are we talking about here statewide. We're talking about 20 positions, 20 ADA positions that would be added if you did the math. I spoke with Pete Scandalakis and Robert Smith about that, and they also came up with the number 20. What Pete did is he asked PAC's HR department to run the numbers of what that would cost the state of Georgia to add these additional positions. What he did is he took what the salary would be for a prosecutor with 10 years experience. And what I'll tell you is the number that they've given me is $3 million roughly. But I'll tell you that in looking at the numbers of what's out there, most of these prison facilities where the circuits would qualify are in rural Georgia. We get very little, if any, county funding, and we are solely reliant almost on state funding. And we're being put in a position of, do we prioritize our local citizens, or do we try to throw our resources in attacking the serious problem that's having in our prison system? And quite frankly, based on the cases that I've prosecuted, these prisons are a breeding ground for gang activity that's affecting the state in a bad way. I'll be happy to answer any questions that any of you may have.
All right, thank you, Mr. Barksdale. You do have a question from Senator Hatchett.
The definition of detention facility, is that prisons, or does that include jails as well?
The way that the bill is written, it cites to OCGA 35-3160. Detention facility means a penal institution under the jurisdiction of the department, including penal institutions operated by a private company on behalf of the department, inmate work camps, inmate boot camps, probation detention centers, parole revocation centers, and county correction facilities.
Good deal. Thank you.
All right, no other questions from the committee. Thank you, Mr. Barksdale. Appreciate your work on this.
Thank you very much for
Did
your
you have
time.
a question? Oh, sorry, you do have a question. Senator Sessions.
So what's the, to be able to prosecute the kind of cases you're seeing in the prisons, and I would imagine in the whole scope of your work, is it fair to assume that the cases coming out of our prisons tend to be more severe, more violent crimes?
Yes, sir.
What level of experience, I mean, I know you make do with what you have, but in terms of how many years of experience would we want to have from a assistant DA coming out of law school to really be able to bring those cases? I know you'd said something about 10 years. What's it really take?
To me, 10 years is the minimum.
Yeah.
I personally lose sleep at night at the thought of losing my chief, who has 30 years experience. Nancy Muscali is another one of my ADAs that will soon retire. These are complex cases and quite frankly, at times a little bit intimidating because some of these guys are serious criminals that have bad intentions. So I would be very hesitant to pass this case on to somebody that had 5 years experience even.
When you hire new attorneys in your circuit, given the pay scale, what do you bring in people on? I know it's public record. This isn't
A brand new attorney right now, and as I said, I have 7 state paid attorneys that handle trial work throughout my 8-county circuit. If they're brand new, which some of them are, they're making $56,000. The county will provide a $5,000 supplement.
so they're making $61,000 a year with law school debt.
Yes, sir.
All right, no more questions from the committee. Thank you. Next, we have Billy Joe Nelson Jr., District Attorney with the Atlantic Circuit. Thank you.
Thank you.
Good evening or afternoon.
It is afternoon now. Thank you for the opportunity to come speak before you all, Senators. I got 2 from my circuit here, Senators Hodges and Watson. I am Billy Joe Nelson Jr. I am the newly elected District Attorney of the Atlantic Judicial Circuit. That covers Bryan, Evans, Liberty, Long, McIntosh, and Tattnall counties. We have a 6-county circuit down in southeast Georgia. District Attorney Barksdale called me last week about this bill being before you all, and I think it's very important, for our circuit to stress the importance of what this bill would do for our ability to prosecute cases. It would be an absolute game changer for me and our office with what we deal with. We have currently 6 facilities as defined by the bill that would qualify. Predominantly Tattnall County is where we see the majority of our issues. We had 3 prison facilities, Georgia State Prison, Rogers State Prison, and Smith State Prison. Georgia State Prison closed down recently. We don't know if that will be rebuilt in Tattnall County, but at some point, it may at some point come back. But we do deal with Smith State Prison and Rogers State Prison. We also have a transitional facility in Claxton, as well as a women's facility in Claxton, and then also the Long State Prison in Long County. The issue of the prison cases has really grown in the last 10 years. I've been a prosecutor in our office for the last 11, going on 12 years. We are now seeing in Tattnall County alone predominantly a quarter to a third of our entire felony caseloads coming out of the prison system. We are having to utilize ARPA judges with the federal funding that the federal government's given us to utilize ARPA judges to come in and handle an entirely separate calendar from what we normally would handle in Tattnall County. So we're having to utilize what we do have in ARPA funding to try and do that. Totally aside from our normal felony caseload. Last Thursday, we were in court picking juries. We had 13 juries to select. Of that, over half of those juries were prison cases. The issue that I am seeing, and as you mentioned with the severity of the cases, is predominantly contraband cases, which are a mixture of inmates, people that are hired by inmates, or correctional officers that are bringing contraband materials in. That can be anything from drugs to cell phones, you name it, we see it. So it's a mixture of that and then serious violent crime that's committed by the inmates themselves. Of note, we've been fortunate enough that Prosecuting Attorneys Council and Mr. Scandalakis have lent one of their full-time employees, Ms. Sheila Ross, to us to help handle a well-documented murder for hire case out of Smith State Prison that's currently ongoing now. We've got multiple death penalty notices that have been served in that case. We have other cases that are spawning out of that particular case. It is a web that is continuing to grow. It is not slowing down anytime soon. The ability to have extra resources and extra help to combat what's going on in the prisons is instrumental for us. I mean, I can't tell you how much of a game changer it would be for us to have the additional personnel to try to help prosecute these cases. I'll
All
take
right.
any questions.
Thank you, Mr. Nelson. Do you have a question, or do you want to move due pass already?
I would be happy to make a move due pass for our district attorney.
All right, before we do that, we have one more person signed up to speak. Any questions for Mr. Nelson? All right, thank you.
Thank
I'll
you.
recognize you in a second.
Okay, thank you.
Unless you changes your mind. Miss Maisie Lynn Girton, I don't think she's not opposing the bill, but yeah.
And Senator Williams, I'm sorry we didn't get to connect today. Chairman, thanks so much for having Gactel speak to this bill. We don't look to oppose this bill at all. In fact, we would come suggesting that you all have done an incredible job of providing equity in our court systems. And in our code, we, in Title 15, each judge gets an assistant district attorney. In Title 17, each judge gets an assistant public defender. So to the extent that you are going to increase the number of assistant district attorneys, I think you ought to also, if there could be a friendly amendment to this bill, increase in like fashion the assistant public defenders that are assigned to that circuit. And as I can't speak to the statistics like the district attorneys can for their circuits, but what I can tell you is that given what they've said today about how a high volume of these cases are coming out of the prisons, even the correctional officers there most likely qualify for a public defender under our code sections, because if a person's income level is 150% of the federal poverty guidelines or lower, they qualify. For instance, a family of 4, the federal poverty guideline is $30,000. We've heard a lot of testimony in other committees over the last couple of years about the pay scales of our correctional officers around the state, and they are quite low. So I would venture a guess that even the men and women who are professionals that are being charged in these cases in these situations likely qualify for a public defender. Though I can't say that they all do. I just don't know those numbers. But from an equity standpoint, we'd ask you to consider adding assistant public defenders at the same rate you add assistant district attorneys in these circuits.
Does the author have any feedback on that? The problem I see with an amendment is that we're different code section. This code section is just dealing with this with assistant district attorneys, so I don't know if we could do that on the fly or if it could be done on the floor with our Senate rules either in the event he wants to offer that amendment. Do you have any feedback on Senator Williams on that potential add?
I'm not sure if it's in a different code section, if it would be appropriate.
Okay. Any questions for Ms. Girton from the committee? Would you?
Thank you, sir.
All right, thank you. My thought is, I'm not sure if you discussed it previously with Senator Williams.
I'm sorry, sir. We attempted to reach Senator Williams this morning by text at the
Okay.
office and just never was not for lack of trying.
I understand. My thought is, in the event the committee wants to move the bill, we go ahead and move the bill and then let him work with you to see if that's something that would match what his intent is with the bill. And okay. Nobody else signed up to speak on the bill. What's the pleasure of the committee?
Mr. Chairman, I'd be happy to make a motion on SB 185 do pass as long as Senator Williams is going to work with the public defenders. I think that's a reasonable approach. Thank you.
All right, we have a motion to pass by Senator Watson. Do we have a second? Second from Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. Did you raise your hand? Okay. Unanimous. Okay. Thank you.
Thank you.
All right, moving back to the agenda at the top, Senate Bill 74. Chairman Tillery. Oh, tough start. Oh, that was the budget. You're trying to send a message. Sorry, I was now see that. Is this your first time in the Senate Judiciary room?
It is this year, Mr. Chairman.
You're a little on edge.
Mr. Chairman, I apologize. I have never presented it. I know a lot of people are nervous when they come to Judiciary, and in my 7 years now in the Senate, I've never presented a bill from this chair. So this is new to me. So thank you.
Well, you're welcome back anytime. A little different role this year, but anytime you want to come back.
Well, thank you so much. And I didn't realize how uncomfortable this seat could sometimes feel. But thank you.
I got to
for
sit there in a
inviting me
minute
back.
myself, so the joke will be on me then.
Well, thank you.
We're
I
working off
appreciate
LC
that.
365422.
I was working off of HB 18, but if we need to work off of that one, we can. Senate Bill.
Nobody really got the joke.
That's fine. Well, thank you for allowing me back. It's good to see so many familiar faces and friends. I do want to talk about Senate Bill 74. It's LC 365422 before you now. And the reason behind it. It's a bill about advertising. We've done some other things about truth in advertising lately in our body, and this bill does the same. As you know, constitutionally protected speech allows puffery, right? You can say things that are slightly exaggerated perhaps in speech as long as it involves some type of commercial purpose if you're trying to sell. We let people say this is the best car ever. However, when that puffery rises to the level of falsity, I think it can also create a distorted reality. And that's what I think's happened and what I'm trying to address here in Senate Bill 74. In legal advertising, I think our puffery has reached a level of falsity, and that falsity has distorted the public's view of what civil justice ought to look like. It's made us desensitized to numbers. It's made us desensitized to how a courtroom works and the seriousness involved therein. So that's what Senate Bill 74 works to address. In Section 1, you'll see that it actually lays out and talks about the views that the Senate already believes about the First Amendment and that speech should be protected. However, when speech is false, it doesn't deserve the same types of protections. In Section 2 in the Fair Business Practices Act, it defines out what a duly licensed attorney is, legal services means, media, and solicitation. To really get to the meat in line 42. In line 42, it says, hey, you can't unlawfully or falsely hold yourself out to be an attorney, a law firm, a lawyer equivalent, etc. And the reason for that is very clear. What we've seen is the creation and the proliferation of what some folks have called runners, or the proliferation of leads. And these leads aren't done by attorneys themselves. In fact, the state bar has told us that they think it's not a really good idea. And so what Section 3.2 is meant to address is that. We shouldn't have leads. We should have attorneys speaking for themselves. Section 3 does state that that's a misdemeanor to violate that previous Section 2. And then in Section 4, you get into some meat again. We lay out what, again, a duly licensed attorney, legal services, media, misleading statements means, and what a material misrepresentation would actually be. To omit a fact resulting in information conveyed being material or representation, to say things that specifically would lead a reasonable person to conclude that a claim or comparison can be substantiated, but it can't, to say things that are erroneous, to falsely portray individuals as clients, or to falsely portray individual circumstances in a light where they would lead someone or mislead someone to believe that the outcome could be certain for them. In line 112, you pick up the meat again, and it basically says the no duly licensed attorney shall solicit in any form of media by a misleading statement. I don't think that's something that we're going to disagree on. If they do, however, we left in the provisions of the previous law that would allow the Attorney General to go after this person. The Attorney General can send them a letter that says cease and desist. That's what current law says. If they don't cease and desist, then they potentially can seek a restraining order against them. They can seek a restraining order. If they don't acknowledge or abide by the restraining order, then they could possibly be guilty of a misdemeanor. But what Section 6 does is it says, hey, listen, in many instances in state law, we don't have the resources. You heard about a resource limitation on the previous bill. We don't have the resources to do what we would like to do and enforce our laws. That's where I think the Seventh Amendment really comes in good for us. And what this does is creates a civil action and says, hey, if the Attorney General can't go after fixing this, then we'll open up a civil action of a violation and give a specific amount for each violation. Allow those claims to be aggregated as a class action to really put teeth in the enforcement of the provisions of false advertising. It would not apply to any contract entered into before the governor signs this, and it's not meant to be retroactive in any way. So if somebody ran an ad today, they're fine. If they run an ad that's false tomorrow, they're still protected under Georgia law. They could say something that's blatantly false, as long as it's considered puffery. But after the signature of the governor, if this was to make it through both chambers and across his desk, then it would be effective from then forward. Mr. Chairman, thank you for the opportunity to present the bill. If you you got any questions, I'll be happy to answer them.
You do have a question from Senator Setzler.
Thank you, Mr. Chairman. I guess there's some bright line tests or some semi-bright line tests that have emerged in case law around this. Is this codifying some of that? I mean, these are kind of murky waters, as you would probably recognize. How do we navigate that?
Well, thank you for the question. I don't know that there really is a bright line test. And what this bill helps to try to do is say, hey, listen, these are the bright lines. Here's the guidelines that you should stay in. Puffery, okay, but when it gets to falsity, it again distorts reality. It's not something we're okay with.
Any other questions from the committee? All right, no one signed up to speak on the bill. What's the pleasure of the committee?
Well, before that, Mr. Chairman, can I mention one other thing?
Yes.
I found what I think is a Scrivener's error, and I talked with Mr. Higbee about it earlier. I think there needs to be a word added at line, I believe it's 112. After media, the preposition by needs to be added.
So line 112 after media, it would say by.
Yes. So no
BY.
duly licensed attorney at law shall solicit in any media by misleading statement. They're not soliciting the misleading statement. They're soliciting the business by a misleading statement.
All right. Is there anything else?
No, sir.
All right. What's the pleasure of the committee? We have a motion to pass by Senator Hodges and a second by Senator Watson. Does anybody want to offer the Tillery amendment? So Senator Hatchett moves that we add the word by on line 112 between media and any. Is there a second? There's a second from Senator Kennedy. Any discussion on the amendment? All those in favor of the amendment, please say aye. Aye. It's unanimous. And now back the airline motion to pass. All those in favor of the motion, please raise your hand. It is unanimous. Congratulations.
Thank you for your kindness, Mr. Chairman.
Thank you. Come back anytime. All right, I'm trying to juggle people having conflicts, so I'm going to throw y'all off and go to the end of the agenda now. Senate Bill 219. Senator Robertson, if you want to come on up and give us a second to locate the bill in our stack. And I show we're working off of a substitute LC 365541S. Is that what you have?
Yes, sir, it is.
All right. The floor is yours.
Thank you, Chairman. Thank you, committee members. LC 365541S is in Sierra. If you'll look, basically the only portion of this legislation is below line 12, where we identify a stun gun or taser lawfully possessed by a sworn peace officer in the course and scope of such peace officer's duties shall not be considered a firearm. And then on line 21, we discussed that how this item is defined in 1611-106, which is possession of a firearm during the commission of crime. But it's just simple adjustment in the language to ensure that this weapon, when used by a law enforcement officer during the course of his or her duties, is not considered a firearm.
Are there any questions for the author? Senator Parent.
Thank you, Mr. Chairman. Thank you, Senator. So the question I have is I'm thinking back to the situation where Rayshard Brooks stole the taser.
Yes, ma'am.
And then was shot. So I remember there being a bit of a conflict at that time internally in some folks' minds, because it was sort of like, well, is the taser, is it not included in the definition of something that would justify using deadly force, right? And so
Yes,
at that time, there were a lot of folks saying, well, yes, it is. Clearly it is like that. So now you're saying that it isn't. So I think we need to be straight on how that impacts,
Yes, ma'am.
the general public, because if we're changing the whole definition, then that also goes with changes it for other situations and also in that particular situation, I would think.
Well, law enforcement officers, when you carry a taser, and I want to be clear, taser is what has become the common language throughout other pieces of legislation and has been codified. Taser initially started out as a brand name. Thomas A. Swift's electric rifle, I think, is where the acronym originally came from back whenever the taser, which stun gun and taser are two different things. a stun gun, if you notice, sometimes when there's not a cartridge on the end of the taser, and the officer takes the taser and contacts the individual and deploys it from that point, it is a stun gun. When the officer has the cartridge on it and fires it, and the two prongs come out and engage with the individual, then it's the true taser is being deployed at that time. And the reason being is, at the time, I think the conflict you're talking about was, I think prior to it, it was used as a stun gun a couple of weeks prior when some college students were stopped, and the district attorney here in Atlanta identified it as one thing when it was used on those citizens, and then a couple of weeks later when it was deployed at the officers at Wendy's is when the district attorney stepped down and stated that the taser was not what he had said it was a couple of weeks prior. But what this does is, when a taser is deployed by a law enforcement officer, it's entirely different than when a taser is deployed by an untrained civilian. Most agencies require law enforcement officers, well, all agencies require law enforcement officers to be trained on using that particular device. The training class is typically, the initial class is around 8 to 10 hours, and most agencies require that officers be tased. I myself, which may explain a lot of my actions, have been tased probably 10 or 12 times, voluntarily and voluntarily every time, I'll say. But yeah.
Can we get one of those to do it around the Capitol as well during session?
We could do that. I would be happy to provide somebody that would come and tase anybody who's willing to volunteer.
Maybe we can do it right now.
But all this legislation right here does is explains that when an individual, a post-certified individual who has been trained on that particular non-lethal, and some use the phrase less lethal device is being used, it is not a firearm at that time. The firearm is a entirely different tool that the man or woman who wears the badge and carries the post certification carries.
Can I ask a follow-up? I'm not sure I really understand the purpose of it, though. I mean, I still have,
Right.
You pointed out those two, and I forgot about the college students right before it, but so I do think that speaks to some cognitive dissonance around use of tasers, that I think it would be prudent for us to have our minds straight as to how we are going to think of them. You know, I mean, whatever the DA chose to do at that time, I thought struck many as well as the situations themselves as being inherently conflictual and therefore problematic.
Yes, ma'am.
So A, I still have questions about that, but B, I don't really understand the point of the bill. So Can you explain?
And I think the point of the bill is, if an individual citizen uses a taser, then in a robbery or whatever, then absolutely, based on the way the taser is designed and the taser is used and the incapacitation that comes with the taser, then, and this is an untrained individual, then the taser can be used in an extremely dangerous and improper manner. But when an officer who is trained, post-certified law enforcement officer trained on this particular piece of equipment, it does not fall into that category.
Okay, so essentially in the first situation with the college students, that would be fine, but so both of those would still play out like in terms of
correct in the situation where the officer used it, and we're not getting into the policy of the agencies. I mean,
I'm just talking about
You're talking about the officers in both of those situations were trained to use those devices in the way they were used, the proper way they were used. And so I believe, and you can correct me if I'm wrong, I don't remember the video fully from the college students, but I believe it was possibly a drive stun. I don't think they actually fired the prongs. I think they reached in and made contact with the individual. So then it would have been used in the stun gun mode, if you will. And then in the Wendy's, I think the device was actually fired, where when it was fired, it sounded like a firearm. And I think that was the word that was used. And in that case, it was used as the taser, if you will.
Thank you.
Thank you. I appreciate those questions, Senator.
Senator Kennedy.
Thank you, Mr. Chairman. Thank you, Senator Robertson. I'm struggling too. What is the, I take it there must be some issue. There's something about the distinction between this definition that is, what is the problem we're trying to fix here? That's what I think is,
the problem
I'm
we're
not
trying to
getting.
fix is identifying the use of force when officers are using particular force. On rare exception, on no exception, any law enforcement agency I've been affiliated with, does an officer carry a tool that he or she has not been trained on. And so I think what this is attempting to do is clarify that if a trained officer is carrying this weapon and using it properly in the line of duty, then it's a tool that can be used. But certain agencies that attempt to purchase these devices, because the devices we're talking about are only sold to law enforcement agencies. Taser does make a citizen taser in lots of pretty colors that an individual could carry in their purse or handbag, and it has a longer duration and everything, but you have to be specially trained on it. It does not look like a firearm.
So, but help me understand, what is the implication of that, and what is the impact of that by a taser not being under the definition of the firearm within the context of police officers and criminal law enforcement? Because I don't think I understand what the import of this is if we pass this.
I think it makes a clear distinction that a taser is not a firearm, and that a firearm is a firearm. If that makes any sense, there's many times that tasers, if you go back and look at studies where they look at deaths of individuals based on law enforcement actions, a lot of times this comes up in the conversation as whether a taser is a deadly weapon or not, and this is just a little more clarification that a taser is not a firearm. So
under our current definitions, is a taser deemed to be a firearm?
No, sir. It's very. The current definition is very ambiguous as to what a taser would be, but taser does use certain technologies that if you got down to the design and everything, because of the chemicals used to deploy the tasers, because in the cartridges, in order to engage, there are primers in there, the energy that pushes the prongs downrange, then there could be some conversation as to where the officer pulled out a firearm and fired it, or whether the officer actually pulled out a less lethal or less lethal device as a taser and used it.
One more, Mr. Chairman. Has there been a case, Senator, where this definitional difference has caused a problem for a law enforcement officer?
I think
or an agency or department?
The vast majority of the problem that we've run into is definition of, an engineering definition, if you will, that if a device uses certain chemicals to say black powder or whatever, chemicals needed to engage the device, then therefore it should be a firearm. And in this case, we're saying it should not be a firearm if carried and used by a post-certified law enforcement officer during the execution of his or her duties.
Okay, thank you.
Senator Jones.
Thank you, Mr. Chair. So, Senator, when I see on the second page when we talk about the definition of firearm, lines 18 to 21, that deals with the Brady situation. I can understand where you're making an exception there, because we have Brady, there's different things that you have to do. And Brady itself says that these types of weapons, which are weapons,
correct,
don't qualify. And so you can make that exception. But this exception that we're doing on page 1, it seems like seems like some kind of way we've charged a deputy with a crime, because that's what it is, that's what the section is. But then we're saying, but a stun gun can't be considered to be a firearm for that. I'm not following.
And that's it. A stun gun and a taser are not firearms. That's the simple change that we're attempting to make.
But the only way we get to that point is if somebody believes for whatever reason, a prosecutor believes for whatever reason that they have committed a crime.
That's correct.
And now we're saying, well, you think they committed a crime, okay, but this does not qualify as a firearm. So I guess why are we doing that?
Possession of a firearm during the commission of a crime would be is the primary focus, and if a crime were if an indictment or whatever was to be pursued, I would assume that if the officer was outside of qualified immunity, it would not be a concern. But if the officer was within qualified immunity, it would be a concern. And I believe, and it would be a defense for the fact that if the officer was doing everything in compliant, that it would prevent a bad actor, i.e., prosecutor, whatever, from charging the officer with possession of or use of a firearm during the commission of a crime. If that disjointed answer makes any sense to you.
Well, yeah, of course, if he's within qualified immunity, most likely wouldn't be charged.
I say within, we're fine. Yeah.
Okay.
Senator Kennedy, Senator Cowsert.
Thank you, Mr. Chairman. So would you consider, or do the courts consider the use of a taser the use of deadly force?
No, sir. There is a certain argument within the body, if you will. And again, I've flip-flopped. Something called less lethal or non-lethal, and you have these interchangeable definitions that move throughout the law enforcement community. I see taser as non-lethal, but people have died due to secondary issues related to taser. The ACLU out of California had a situation where an individual had been tased several times. When they got to the county jail, they were able to find some glass or something. They cut their wrist, and it was considered to be a taser-related death. And then there are others through excited delirium deaths that deal with the pH balance in the blood system that you primarily find in individuals who have had contact with law enforcement officers and been restrained, or within mental health environments that have been restrained. And some of those have been classified as taser deaths because the individual have been exposed to the device prior.
I was just wondering, thinking back to the Wendy's incident, I mean, the officer's defense was that the individual's use of a taser pointing at them justified their use of deadly force against him, which made me think it must have been considered the use
what the
of deadly
taser device
force.
does, and again, I've been exposed multiple times, it's an incapacitating device. So in other words, if you came to me and wanted to take whatever I had, whether it be my firearm, my handcuffs, my aspeton, or whatever, if you attempted to take it from me a mano, your chances would be very slim. But if you were able to deploy the taser and engage the taser me, you would incapacitate me, and you would be able to take the other weapons that I had on me and definitely use them against me. I've never felt that my life was in danger by being tased, but there was no doubt I was incapacitated by being tased.
Any other questions for Senator Robertson?
And Mr. Chairman, I'm very comfortable with this just being a hearing if we need to clarify some things. So whatever, I just want to make you feel comfortable, Mr. Chairman.
I appreciate that. You always make me feel comfortable when you're in the committee room.
Well, I know Senator Tiller just got his first bill passed,
Right.
and so I know you're still on a high from that.
I am. All right, we have one other person signed up to speak, Miss Maisie Lane Girton, along with Arturo Corso, if I said that correctly.
And Mr. Chair, I'm on exit. I'm late for that meeting.
Okay, thank you.
Yes.
Thank you for
Good to see you again.
Yes,
Welcome.
Of course. This is Arturo Corso. He is our lawyer of the week. He practices folks out of the Gainesville area, but also federally, and will bring some practice experience that I haven't had in quite some time to you guys today. We have some of the same concerns that you all have raised here today, and just wanted to address a couple of those before I turn the mic over to Arturo. Senator Parent, just for your edification, we do have a code section in our law that addresses just exactly the kind of situation you were talking about. It's 161033, the removal or attempted removal of a weapon from a public official. It specifically says that the term firearm shall include stun guns and tasers. And I think this is also a good moment to say that as much as I can appreciate the distinction that Chairman Robertson makes around the stun gun versus taser functionality of these devices, our law does not seem to distinguish between those. And it goes on to describe what a stun gun is, which I'm not sure, I think it might have been Senator Kennedy who was asking about the precise description of these weapons. And each of the times that it's used in this way in the code, it does explain that it's a device that is powered by electrical charging units such as batteries and emits an electrical charge in excess of 20,000 volts, or is otherwise capable of incapacitating a person by an electrical charge. So it's not like there's no question about what these devices, what the law is meant to curb.
That's currently defined as a firearm.
In code sections, independent code sections, yes. So for instance, in this removal code section 161033, that includes stun gun or taser. In the code section we're discussing today, which Senator Jones was mentioning, just to set the context, we are not talking about redefining the term firearm when it's being stun gun, when it's being carried by a law enforcement officer just in the common everyday duties that they offer us in service to the community. We're talking about a peace officer who is suspected of criminal behavior in 1611-106. And in 1611-106, yes, Chairman, firearm shall include stun guns and tasers and has that same description that I just read to you from the other code section.
And that code section, does it just deal with officers, or is that the general code section for possession of a firearm during commission of a
It covers
crime?
everyone.
Okay.
Mr. Chairman.
Yeah, thank you.
So in fact, what this bill does is it changes. You want to just describe how it changes the...
Yeah, I think the thing that good afternoon, everyone. The thing that I found most concerning is the kind of the placement. As one of the gentlemen already said, Senator Jones said, you're putting this under a code section that's already dealing with someone who has been accused of committing a certain crime. So the only true impact, Senator Parent asked, kind of what are we achieving here? The only real impact is that a peace officer who is indicted for a felony and then is also indicted for possession of a firearm in furtherance of that felony or during the commission of that felony would be able to come to this amendment and say, oh, but when I used that stun gun or taser device and committed this aggravated assault or possibly felony murder on a suspect, you can't give me a consecutive 5-year penalty. That's what the whole section 11 sorry, what did I say? 1611-106 is to add a 5-year consecutive penalty upon conviction. And then with respect to the second part of the bill, I still had some kind of puzzlement about why we were trying to exclude this from coverage under the Brady bill. I just didn't really understand what the point of that further modification is. So I feel like it's trying to do two completely different things in the wrong place.
All right. Any questions for the committee for Ms. Gerton or Mr. Corso? All right, thank you.
Thank you.
That's everyone that signed up to speak on the bill. Unless there's strong feelings from the committee, we can hold on this one to work on it in the coming weeks and year. All right, that's what we'll do then. At the request of the author, right? And so that's what y'all heard too. All right. Thank you. We'll go back on the agenda, and I'm going to ask Senator Cowser, I keep wanting to call you Kennedy tonight for some reason. I don't know what it is. The vice chair to come up and preside as I try to present Senate Bill 157.
All right, Mr. Chairman.
Well,
Proceed. Senate Bill 157.
All right, I'm working off a substitute LC 365513S. That's what everybody else has. And this is an 81-page bill, and I will not go through all 81 pages unless y'all just make me do that. Senate Bill 157 comes, I want to talk just for a second about where it comes from and what we're trying to accomplish, and I'll briefly go through the provisions. It comes from a working group that was started a couple of years ago, some senators and representatives without a title. Just some of us have gotten together and worked on some other issues that have continued in the criminal justice reform area beyond the Criminal Justice Reform Council that expired a few years ago. And with this bill in particular, we were looking at workforce and trying to do what we could to make sure there are less barriers to getting folks back into society that want to get back into society after they've paid their debt to society following a conviction or a charge. And in particular, we looked at licensing, occupational licensing. In this bill, you'll see there's really three different areas we're looking at. One are our Secretary of State licensing boards, one are independent licensing boards, and there's a separate section dealing with long-term care facilities. And what we're doing is we are creating a consistency amongst all of our licensing boards when it comes to what they will look at with someone's criminal history, what keeps them from working in a particular field, making sure that whatever offense you have on your record is directly connected to the area you want to work in, to make sure we aren't setting artificial barriers for employment. And so I'll briefly walk through what the bill does, and I'll do that by focusing on Part 1, because once you get through Part 1, it's pretty much the same thing for the rest of this, and I'll point out the distinctions. Part 1 deals with our Secretary of State licensing boards. And in this, we define what a felony is. That's being looked at as a felony. We also define what's being looked at as a misdemeanor. First, on misdemeanors, we're going to look at all convictions within the last 5 years. And we're also going to always look at certain offenses such as family violence offenses, offenses against children, sexual offenses, and serious traffic offenses. So when a board is looking at someone's criminal history, those are the areas they're going to look at. When it comes to felonies, you're going to always cover convictions for sexual and violent offenses, fraud or embezzlement, child abuse, neglect, domestic violence, any conviction or incarceration in the past 5 years. What you're not looking at are arrest records without subsequent convictions, someone's been pardoned, expunged, or vacated, first offender convictions, which is not a conviction, first offender offenses, misdemeanors older than 5 years, unless they were those covered misdemeanors I said a minute ago, and convictions where incarceration ended more than 5 years before the application, with the same exceptions for sexual or violent offenses, fraud or embezzlement, or child abuse and neglect. Here's the important part, getting to sections 1.2 and 1.3 of the bill. In looking at those offenses I outline, you will now have a clear burden on the actual licensing board, a clear and convincing evidentiary standard, burden of proof on their part to say that a conviction supports an adverse licensing decision. That's important because you also get into this bill for the appeal process, the administrative process for appeal through our Administrative Procedures Act, where you will have the board with a certain standard they're looking at, making sure that the offense that disqualifies you is directly related to the profession, and that you would pose a direct and substantial risk to the public, to public safety, because you have not been rehabilitated to safely perform the license duties and responsibilities. In rehabilitation, that's something that is not clear into the code right now. You get a standard definition for what a board will look at as whether or not somebody has been rehabilitated. You also looking at, I'm still in Part 1, now we're in Section 1-4, which I see all y'all are following along, every single line. You're still awake at least, Senator Cowser. I can't talk about a 80-something page bill for 30 seconds. Come on. You look at vague standards that you currently have with these boards, and this is really something that I think is also good for board members, because you have a board member trying to figure out if someone has good moral character, moral turpitude. Senator Mullis always liked that word. Looking at character and fitness. It's getting rid of those kind of standards and actually setting a standard to say, these are the crimes we're going to look at, and then you've got to show that that is directly connected to the industry that you want to work in, that you're a threat. The other part of this, as I said a minute ago, is the appeal process is being set up. that'll make it where hopefully anyone can navigate an appeal process, and an initial decision to deny you a license is something you can appeal at that point and get heard at that point as well. The other big part of this is you are going to now have public information on a website for every board that says which offenses keeps you from qualifying to get a license. You're also going to have a what I've called kind of a pre-clearance, it's actually predetermination in the bill process, where someone can go and say, I want to be a nurse, yet I've got this on my record. Before I try to go and get the schooling and the training required, let me see if this keeps me from being a nurse, and you can then go for a board for a predetermination as well. The idea of this is a lot of people may think because something's on my record, I can never work in this industry, so I never even try. I don't have the resources to invest just to be denied the chance to work in a certain industry. I'm going to make the rest of this a little bit easier. Everything I just said is all in part one. We then take the licensing boards and the Secretary of State. We have to go in the code for every single other licensing board we have. And that's parts 2, 3, 4, and 6. And we do the exact same thing. We set the same kind of standard up for our accountancy board, dentistry board, composite medical board, real estate commission, appraisers board, structural pest control commission, professional standards commission, pharmacy board, and insurance commissioner. And then when you get in part 5 of the bill, this is a little bit different, looking at long-term care facilities. They have some different language already in the code when it comes to the crimes that they're looking at. And we're going to maintain the current 10-year disqualification period for conviction, but we're going to make that start instead of the date you finish a sentence, on the date of conviction itself. And then it's the same covered misdemeanors I mentioned earlier that will be looked at, and the same felonies that will be looked at when someone's working in a long-term care facility. The same standard to make sure that a denial because of something in your record is directly related to the occupation that you grant, and that you pose a direct and substantial risk to the public. And the same predetermination process and the same publication process will also be set up for our long-term care facilities. Basically, if you have a history of stealing from people, you probably shouldn't be working with our most vulnerable. There are certain things we know are no-brainers. Certain folks are not qualified to work in certain industries. But what we don't want is to have a system that's so complicated to where you have people that truly want to get a job and become productive members of society again, but can't navigate it. We also don't want boards making different decisions with generic language such as good moral character without any idea what that exactly means. So I've been very brief in going to the details. A lot of work has gone in this bill. You're going to hear, I think, a lot of folks sign up to speak that have worked behind the scenes supporting this bill. And I look forward to continue to work this bill through the process. I had some meetings today with the insurance commissioner and also with our Secretary of State's office with some potential changes they want to work into this as well. And I promised moving forward I'd work with them, but there's more stuff we need to do through this process as well. This is a big lift as you sit here and go through every single licensing board in our state and make this big change. With that, I'm happy to answer any questions.
All right, I've got a question from Senator Hatchett. You're recognized, Senator.
My question is about the definition of directly related. You see it first on page 3, line 63. I noticed it's not in the definition section. Is that just kind of left up to the discretion of the professional licensing boards?
Yes, so it's multiple places. You're going to see it again. Let's see, you're on line 63.
Yes.
I'll just look, see if I can point to another line to look at while we're here. But that is the standard we're setting up. It has to be directly related. And so, look, I had one person reach out and said, we're worried this bill doesn't go far enough. You know, you're still some discretion for our boards. But that's what I think we need, is we need to still have some discretion there. And so it'll be up to those boards to decide whether or not that directly relates. But there is more guidance. Maybe one of the other speakers will point to that. There's another section that outlines this a little bit further when you get to individual boards itself.
I think I just want to make sure we're clear, and didn't know if we needed to say directly related to the profession in which they are licensed, because it could be somewhat ambiguous, just been convicted of a directly related felony. I don't want to throw a wrench in your bill or anything. I obviously support it, but just wanted to make sure we were clear.
Yeah, what I was going to point you to was lines 153 through 161 as an example. You'll see otherwise of the full standard of what a board looks at. But that's just narrowing down the actual crimes that'll be looked at. So you have the initial definition I told you, what is a covered misdemeanor, and then what felonies are looked at. And then you have the board has to directly connect those offenses to the offense. And that's kind of your standing of these are the offenses we're going to look at, without us getting into every single board and saying for cosmetology it should be this, 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 and this. Does that make sense? It's kind of your initial, which crimes are you going to look at? Then you get into, if you look on lines 153 through 161, you really see how it's going to be covered, where you have the burden on the board of showing that the person granting the license would pose a direct and substantial risk to public safety. Does that make sense? And maybe someone else can further clarify that after me.
Thank you.
Senator Watson, you're recognized for a question.
Thank you, Mr. Chairman. So help me understand here the felonies are lines 227 through 235, I guess. And I'm just struggling with, it doesn't look like drug abuse or drug use, like with cocaine is, the recidivism rate with cocaine is pretty dang high. I know with physicians, 5 years is the minimum aspect related to supervision. And so would that be included?
Well, you'd have to have been out of jail for more than 5 years. So if you've been out of jail for more than 5 years after serving your sentence, then you are more narrow in the offenses that are looked at. And you see the ones listed out, 227 to 235 there.
Well, maybe not in jail. What if you're admitted cocaine use or you did rehab and never went to jail?
Well, you'd still be on probation. So when I say out of jail.
No, as in never, no conviction, no arrest.
Okay, then I'd say no, that would not be something that a board would be able to look at when it comes to criminal history.
Okay. So you could do rehab for cocaine and then recidivism rate is like 75% or so.
Yeah, and so the situation you're given, I guess you probably, I'm not sure if somebody could do first offender. I guess they could. They could do first offender.
Never arrested.
Well, they're never arrested, then it's not even being considered if it's not. This is criminal history. So we're looking at convictions. Now, if they were arrested and they didn't move forward with the charges, then that would not be something that would be considered either. We're looking at criminal history that denies somebody a license. So I don't think your situation, if you're never having arrested, this bill really doesn't impact that.
But if you were, it's not listed there either, right?
If you finish your sentence after 5 years and not committed another crime, then
okay.
Yeah, that would not be a crime that could be used in
So
itself.
you could be a pharmacist or
No, so here's the distinction. You wouldn't be able to use the mere fact you have this on your record to deny you the license, but obviously we're not changing the other standards that the boards look at when it comes to someone obviously that is an admitted user of a drug, like you said. I'm sure the pharmacy board would still be able to deny them a license.
But if you were convicted and served your 5 years, you would be.
If you've served your time, the idea is to have some sort of cutoff, right?
And it's been 5 years.
Mm-hmm. I don't know if there's any other exception they could look at, but that, as far as the criminal history, that would be considered. That's correct.
Okay. And are we doing? Is this hearing only, or I didn't hear
What
that.
it's supposed to be.
I got you. Okay. 9-9. All right.
But unless he hits a lot of
Unless I get
questions
a
and
lot of-
roadblocks.
Okay.
Well, it looks like you're giving me.
Okay. All right, that's all the questions from the committee. Let's hear from some
And maybe they'll
other
answer that
testimony
question
here.
better for Senator Watson.
Wade Askew and Emmy Williams, Georgia Justice Project.
Answer that question for him.
Do our best.
See if you can save the chairman's bill for him here.
We're always having to clean up.
Please introduce yourselves and give us your thoughts on it. Senate Bill 157.
All right. Good afternoon, everybody. My name is Wade Askew. I'm policy manager at Georgia's Justice Project, and sitting with me is Emmy Williams, a staff attorney with us, who I'll be kicking it over to in just a second. But just to briefly introduce who we are, and then I'll address those couple specific questions first. Georgia Justice Project, we're a nonprofit. We serve Georgians throughout the state who face barriers due to their old criminal records. So every day, folks contact us because their record is posing a barrier. 9 times out of 10, it's a barrier to work. That's why they contact us. And so to add just a little bit of color as to the average person who seeks our services, they're 43 years old and they have a record that's usually over 10 years old. So many folks know us for our record clearing work, people helping folks apply for restriction and sealing, but we seek to serve folks holistically. And so about 1 in 5 people who contact us actually have a question or at least an interest in pursuing a career in a licensed field. And so we, for a long time, have represented individuals in licensing petitions and at minimum given a lot of information as to here's what's on your record, here's what you can expect moving forward. And so Emmy will speak about that in a little bit more detail because she's represented a great number of individuals seeking careers in licensed fields. First, just wanted to speak to the directly related definition. I appreciate that question. Under current law, under 43119A6, the term directly related already exists, so it's not a new term being introduced in this bill. The boards and agencies under the umbrella of the Secretary of State already have a statutory duty to do an evaluation to see if a conviction is directly related to that licensed profession. So I think we'd certainly be open to making sure, as you mentioned, we're talking about directly related to that profession, so we can take a look at that language. But just wanted to note that is in a term that's already in existence and already being used. The second question around drug use specifically, so boards can consider, and they can and do consider whether there are any issues generally that affect the fitness of an individual to practice in that field. And so I believe that they all, to my knowledge, pointedly ask, do you have any drug use issues that would cause issues here? And so as Chairman Strickland said, this bill is specifically looking to how do we deal with criminal history, criminal records. And so if an individual doesn't have an actual criminal record related to drug use, then that wouldn't be covered by this bill because this is specific to criminal history. However, the boards have other tools and they have other mechanisms to investigate any other potential fitness issues that could pop up, including history of drug use. And I did just want to note that in this bill, we did write in for the pharmacy board specifically, because for obvious reasons, drugs are important to the pharmacy board, that they can look at convictions older than 5 years that involve drug use. So we actually had a specific provision for the pharmacy board for that reason. Excuse me? Composite board, I don't believe
there, but it could be. So.
Right. So at that point, that specific carve out was for the pharmacy board. But as Chairman Strickland noted, if that individual had gone 5+ years clean, then that's at that point when that criminal record would not be considered anymore unless it was on that specified list. So I'm very happy to kick things over to my colleague, but we're absolutely happy for questions.
Before you do, I'm going to recognize Senator Setzler for a question of you.
Thank you, Mr. Chairman. Appreciate the advocacy work you do. I take it your goal would be to make this as broad, sort of in terms of across the professions, the broader array of professions that this could apply to you, you think would be welcome?
That's right.
What would you think if we take the same standard and apply it to membership of the state bar? Would you support that?
I appreciate that question, Senator Setzler, and as members of the bar, I think personally we would welcome that. However, there are constitutional issues that could pop up because the bar is really under the jurisdiction of the Supreme Court, and so that is the only reason that the state bar is not in this bill.
If we applied this framework, do you think the bar would welcome this framework for attorneys?
I think so. Actually, some of the provisions in this bill, the bar is already doing. The bar does offer for individuals interested in law school the ability to go ahead and get an evaluation of their records. So the bar is doing a number of these things. I should also mention real estate already does the same thing with the predetermination process, which this bill would not disturb. They're doing great. We've talked to them about it, and they love their process, so we're not going to touch it.
Which licensed professions under Title 43 does this not apply to?
Title 43, everyone. So there are a couple of independent license board that are not under 43 that this doesn't apply to, but everybody under 43 it applies to.
On line 236 through 238, if you guys would take a peek on page 10, I just have a general question for you. I just want to, since you guys are practitioners, I just want to understand how this plays out and how this works. Line 236, notwithstanding any other provisional law, which is a pretty broad net.
Sure.
No professional licensing board may apply a vague character standard to licensure decisions or predeterminations, including good moral character, moral turpitude, or character and fitness. What standard can they apply if they can't apply those? And I think in terms of, I joke all the time as I'm driving over a bridge, or you're taking Spaghetti Junction from 35 to 85. I tell my family, kids, think of structural engineer. He did his he or she did their homework, or this big flyovers. It's kind of a scary thing. You need people that are reliable, fit, on the job, accountable to others. What standard is appropriate for character if these kind of broad statements aren't appropriate?
So really what we're seeking to do is to say, Chairman Strickland kind of described the standard, again, as it pertains to criminal records, because boards are going to have a number of requirements completely unrelated to what this bill is doing. You have to have completed a certain level of education. You have to have completed a certain level of training. You have to, not have unrelated issues that could affect your fitness to practice in whatever field. That's all still preserved. So what this is seeking to do is to say, instead of saying, well, we're going to look at crimes that involve moral turpitude, which is an issue for kind of everyone. It's an issue for the board, either in one of two instances. One is it doesn't really tell the board what we want them to look at. And then two, it actually creates more work for the board. So we spoke with folks at one board over the summer who they're having to keep track of every court decision in the state that mentions the words moral turpitude. And so add that one to the list. I guess that involves moral turpitude now. And so it creates actually more work, more administrative work, to have these kind of vague standards for those boards that do want to be as specific as possible. And so instead, what we've replaced those terms with are what Chairman Strickland described of saying, okay, felonies, here's what's considered, here's what's not. Misdemeanors, we have this definition, what's a covered misdemeanor, and then what are both the felonies and the misdemeanors that we all agree on, that we say no matter what, these are under evaluation.
Does this apply to CPAs?
CPAs? Yes, it does.
Mm-hmm.
So the person doing audit work and financial work for a publicly traded or privately held company, this standard couldn't be applied of moral turpitude, character. You could have somebody that's 6 years removed from a felony. Just want to, again, there's the question of support, and there's the question of clarity. I'm just trying to get clarity on the scope of the bill and make sure we understand what this applies to. Because I'm broadly in support of providing access to certain trades that are licensed. You can name them. There's trades that estheticians and barbers and whatnot that you have people could do credible job. I'm trying to draw a distinction between estheticians and barbers, this is sort of being talked about in. That's very different than a CPA who's in an audit practice and is got a big four accounting firm's name behind them. That's a lot of responsibility for somebody that has a criminal history. So
Sure. And so I would just say two things. One is kind of the current state of the law and why the current law kind of relies on this directly related notion, and why this kind of really is trying to build on that and clarify and strengthen it in a lot of ways, is because you're right. We are looking at 50 different professions that do 50 different things. And so what makes sense for one might not make sense for the other. And so that is why there's still this level of deference and this level of acknowledgement of each individual profession is an expert in its own profession. And so they are applying the criteria that makes most sense for that board. And so that's one note, is that logically what there might be a broader kind of universe of offenses that one board is going to be concerned with than another. The other would be that, the 5-year kind of look back period that we're talking about, that wasn't really pulled out of a hat. Really what that's based off of is the data that we know to be true around recidivism. And so what the data tells us is if somebody goes about 3 to 5 years without an arrest, then they are now no more likely than anybody in the general population to be arrested again. And so what we're trying to do is kind of equip boards and actually make things more efficient for boards so that they can spend more time and more resources on the offenses that really are relevant. And so our hope is that this would actually be assisting boards and actually improve public safety through both reduced recidivism, because more people at work means less recidivism. The statistics bear that out. A good job cuts recidivism in half. But also to build off of what we already know, which is if somebody hits that 5-year mark, then they're no more likely than anyone in the general population to be arrested again.
All right, Emily. Emmy.
Good afternoon. Thank you, Mr. Chairman and members of the committee. My name is Emmy Williams, and I'm a staff attorney at Georgia Justice Project. And for the past 2.5 years, I have been studying this issue and representing individuals with criminal records who are trying to understand their eligibility for licensed professions or who are in the process of becoming licensed. And so I'm here to share with you a bit about what I have learned and the experiences that people with criminal records who have tried really hard in their lives to move beyond their record, how they are encountering barriers in the licensing process. So 1 in 7 jobs in our state requires an occupational license. And in fact, 1 in 4 of Georgia's most high demand jobs requires a license. And we can see this. We know that there are workforce shortages going on. We can see that many of those jobs that are experiencing shortages are licensed. And these careers span so many fields, from nursing to cosmetology to interior design, if you can believe it. Other jobs also require facility clearance, like long-term care facilities, and these are licensed facilities that are facing their own staffing crisis. Georgia actually has the 4th lowest staffing nationally for aides and nurses in our long-term care facilities. So like each of you, as we've been looking into this problem, we have heard from numerous stakeholders and business interests about the need to eliminate regulatory barriers for qualified individuals who are hoping to fill vacancies in these fields. And we believe that occupational licensing reform is what will help employers fill positions of need, and it will also improve public safety in our state through reduced recidivism. This is why groups like the Georgia Chamber of Commerce and the Metro Chamber and other numerous stakeholder groups support this bill. In addition to our experience representing clients on the ground and talking with stakeholders, we have also studied best practices that other states have implemented. So our neighboring states have already implemented many of these reforms, actually all of these reforms. We didn't invent any of these. They are being implemented right now by Louisiana, Mississippi, Missouri, Kentucky, and North Carolina, all states, just a few of all of those that have incorporated these reforms. SB 157 is really to catch us up with our neighboring states when it comes to accessing talent in licensed fields. And it will make the criminal record evaluation process for licensure more transparent, efficient, and fair. And to kind of give you an example of this afternoon, you'll hear from one of my clients. His name is David. He is currently facing barriers in his journey to become a licensed physician assistant because of his record from over a decade ago. David's story actually echoes so many that I have heard over the years I've been doing this work, from those who aren't sure if they are eligible for a license, those who can't get evidence that they are actually rehabilitated and safe to practice in front of a licensing board, and those who have been denied a license who don't have a good option to appeal. There are so many Georgians like David who want to pursue licensed professions. They want to contribute to our state as professionals, and they can't because of records that do not reflect who they are today. SB 157 will lower these barriers and allow so many more qualified, motivated individuals to fill empty jobs in licensed fields. Thanks for your attention to this issue. We're happy to continue taking questions if you have them.
All right. You don't have any questions. I'm going to tell you all in the audience, we have 6 more people signed up to speak, and each has indicated they are in favor of the bill. I just want to implore that you don't talk the bill to death. You will invite questions, and inevitably it gets things a little more hung up. If you're for it, you don't feel that you have to speak for too long. I have David Johnson, who you just referenced, Emmy. Buzz Brockway is here from the Georgia Center for Opportunity. Mac Parnell from Georgia Faith and Freedom. Rachel Shanklin from the Small Business Majority. Megan Middleton from All Century Food Bank, All County Food Bank. And Pat Horton from the Georgia Center for Nursing Excellence. All are in favor. Any of you that would like to be heard, you're welcome to. If not, I just sort of let the committee know what wide support for this bill at this point. We went till 7:38 our last meeting, and I don't believe we'll keep a quorum that long tonight.
We won't hold you hostage.
So we'll start with Mr. David Johnson. If you have anything you'd like to add to us, I think you might have an interesting story.
Thank you, members of the committee, and thank you, Chairman Strickland, for your leadership on this.
If we can try to keep it no more than 5 minutes each, that'll narrow us down to at least another 30 minutes, but the quicker the better. Go right ahead, sir.
This is a little intimidating. I'm David, and to save time, I can submit this for document to the committee. I don't know how to do that.
You just bring it up here and hand it to me. But if you'd like to just tell us a little bit about your story. Thank you.
Well, you just took my paper. So my name is David. I'm an alcoholic. I've been sober for 12 years. I grew up in a pretty terrible family. My mom was an alcoholic. Every husband she's ever had was an alcoholic. I'm here in the hopes that you'll pass SB 157 because I want to show that through hard work and a 12-step program, anyone with a story like mine can change, and they can change the outcome of their life. The person you see today is not the same person I used to be. It's not the same person you see that is permanently transcribed on my background check. Yet because of my criminal record, I'm not going to be, I won't confidently be able to pursue a license in into a physician's assistant job. Sorry, I'm a little nervous. I believe some people are born with addiction, and that it's passed down through genes. My mom made sure that I was going to be an alcoholic when she drank while she was pregnant with me and my twin brother. I never had a chance at a normal life. We were born premature and underweight. My biological father died of alcoholism. My mom's second husband sold drugs, and her third husband was a pedophile. By age 13, I was in foster care. I was a very troubled teenager and moved through 4 foster families, 2 group homes, and 6 schools in 3 years. By age 18, I was a daily alcohol user and drug addict. I ended up with a first offender case for drug possession in 2010. When I was 24, I enrolled in an inpatient treatment facility after an arrest, and I've never been arrested since. My sobriety date is October 21st, 2011, and it's the day my life changed forever. During my rehabilitation, I got my GED, and I found a better life. I found friends. I found a family. And I told myself, I pledged myself that I would do the next right thing and help as many people as possible. I ended up going to a 12-step meeting every day for 5 years, made a lot of friends. Doing all that while being drug and alcohol free. I finished my first offender's probation successfully in 2016 and decided to become an EMT and enrolled in Grady EMT Academy, and then went to Grady and was working on an ambulance. In 2019, I applied to Georgia State University for a biology degree. I am currently a senior at the university and currently have a 3.98 GPA. Since I started school, I've made the president's list every year, and I've been at the top of my class. My plan after graduation is to get into a physician's assistant program. I love helping people and finding solutions in tough situations. Being a PA is my dream job, but I'm afraid that my bad choices and previous history may hinder me getting that job. The medical board could deny me a PA license because of my first offender case, even though it's not conviction and is over 12 years old. I would also need to tell the board about the arrests, even the ones that I wasn't convicted of. This has discouraged me from applying for PA school because I don't know if I would get a license and spend all that money, time, hard work, and even now. A biology degree is not easy. It's very hard, but anyways, passing SB 157 would make it possible for me to become a physician's assistant. The predetermination process in this bill would allow me to understand whether I'm eligible for a PA license before I invest my time, money, and energy into PA school. This bill allows my full story to be considered and wouldn't be judged on my first offender case. I would get a fair chance of becoming a PA with this bill because the law would finally recognize that I have worked hard to change my life. If you told me 15 years ago that I would be this happy, this motivated, or this successful, I wouldn't believe you. I'm a different person today. If the legislature passes SB 157, people like me will have the hope that their mistakes can be forgiven and that they become something unbelievable to the person they were, becoming their own hero. Thank you for your time.
Mr. Johnson, thank you for having the courage to share your personal story with us. It's inspirational to us, and it shows how you can turn your life around when you put your mind to it. And Americans believe in redemption. So you keep up the faith and keep hammering on, and we'll do the right thing here. Thank you for being with us today. Nobody has any questions for you.
Thank you.
Buzz Brockway.
Thank you, Mr. Chairman and members of the committee. I appreciate it. I'll be brief. I know you've been examining a lot of bills, and I appreciate it. And, my name is Buzz Brockway. Currently work at the Georgia Center for Opportunity. And I wanted to add our support to this bill. I think a couple of stats that I want to give you. Nick Eberstadt of the American Enterprise Institute, in 2019, I believe it was, but prior to the pandemic, wrote a study about men without work. And at that time, there were about 8 million men across the United States who were unemployed for various, for unknown reasons. A further study of that number that he has done has shown that there's a large number of that are folks with a criminal record who just have a hard time getting a job. Here in Georgia, a couple other stats for you to consider that I think this bill could help address is, we've done a pretty good job through the hard work of the governor and y'all in the legislature in recovering since the pandemic. Our unemployment rate now, last I looked just the other day, is around 3%. However, if you look also at the workforce participation rate, you see that we have not gotten back to where we were prior to the pandemic. Our estimate is that there's about 250,000 people in the state of Georgia who have not returned to the workforce since the pandemic. Thankfully, we're still a growing state, and a lot of those jobs have been filled by folks who moved in. So I think that what this bill does, it provides a framework, as y'all are seeing, a framework for licensing boards to consider this kind of information. It doesn't undo other things that the licensing boards can and should do. However, we need to, as much as we possibly can, encourage those folks who are out of the workforce or have been knocked out of the workforce by COVID to get back into the workforce. I know our employers are clamoring for folks, and if we can provide that process in law, then I think that would be a great thing. And so I appreciate your time today. Thank you, Mr. Chairman.
Any questions for Mr. Brockway? All right, thank you. No questions. Mac Parnell, look at you, already halfway there. Good move.
Mr. Chairman, or I guess Mr. Chairmans, thank you all so much. Members of the committee, thank you so much. I'll be very brief. The Georgia Faith and Freedom Coalition is in favor of this legislation. You'll find a letter from the Metro Atlanta Chamber of Congress, the Georgia Chamber of Congress, and the Georgia Faith and Freedom in support of this legislation. Very briefly, following up on some of what you've heard from other speakers, I was speaking with a good friend of mine who owns a staffing agency, one of the largest staffing agencies in Northwest Georgia. And she said that I spoke to her specifically about this bill, and she said, man, if I could have 1,000 people, I could put them to work tomorrow within 24 hours. And this is a workforce development bill, and in our view, this builds strong families and strong communities, and it's a win for Georgia. Thank you so much.
Thank you. Rachel Shanklin.
Good evening, committee members. Chairman Strickland, thank you for introducing this bill, and hello, Vice Chairman Calzert and members of the committee. I am Rachel Shanklin. I'm the Georgia Director. I'll also be very brief. I'm the Georgia Director for an organization called Small Business Majority. We are an organization focused on supporting and advocating for Georgia's small business community. I'm here as a representative on behalf of Georgia's 1.2 million small businesses in support of Senate Bill 157. This is legislation that will give Georgians a fair chance and expand our state's skilled workforce by making it easier for entrepreneurs and job seekers to obtain occupational licenses. We know that Georgia is a great place to live and work, and we also know that we've been named the number one state for business for 9 consecutive years. But like many other states, as my colleague just alluded to, we are facing an ongoing talent shortage. To keep our growing workforce and strengthening our economy, we need to ensure that we have a diverse talent pool. In fact, according to recent polling by Small Business Majority, a vast majority of Georgia small business owners, 85%, support reforms that would allow people with prior convictions fair access to occupational licenses, enacting measures that would reform occupational licensing, and allowing individuals with convictions will help close this equity gap and also open the door for opportunity. By pushing for this type of meaningful legislative change, individuals can find career opportunities and also be less likely to seek government support. For our neighbors that have paid their debt to society and are willing and eager to work, we should create opportunities that reduce recidivism and make it easier to start or work for a small business. These measures will enable an expansion of the pool of candidates that are ready and willing to rejoin and contribute to society, and opening access to occupational licensing will help grow Georgia's economy and make sure that Georgia remains the number one state for business. So thank you for your time, and I'm happy to answer any questions.
Thank you. There are no questions. Megan Middleton.
Good afternoon, Mr. Chairman,
Afternoon.
members of the committee. Thank you for allowing me to speak. And Chairman Strickland, thank you for introducing this legislation. I apologize for my handwriting, Mr. Chairman. My name is Megan Middleton. I'm with the Atlanta Community Food Bank. And we are in support of this bill. I will quickly just say that the Atlanta Community Food Bank services 29 counties in the South Metro through Northwest Georgia area. Last year alone, we distributed over 73 million pounds of food and groceries to those Georgians. We are in support of this bill. We look at food insecurity and how we solve that issue in a holistic manner. So this is one of those ways that we can really help people to get back to work. It's common sense change that's needed in the state. It will put people back to work, like we say. And with more people working, they'll be able to afford those necessities that we all need food, rent, mortgages, car repairs. So we believe that this is really common sense legislation, and we wanted to show our support along with all the many vast supporters of this bill, and ask you to pass Senate Bill 157. Thank you.
All right, thank you. No questions. Pat Horton.
I guess good evening.
Yes, thank you for being with us.
Thank you for giving me the opportunity to speak today. I lead the Georgia Center for Nursing Excellence, which is a nonprofit organization instrumental in convening and collaborating with stakeholders across Georgia to develop strategies and solutions that address the nursing workforce challenges and expanding the nursing workforce pipeline. The Georgia Center for Nursing Excellence has partnered with the Georgia Justice Project to support occupational license reform. This is the perfect time to support occupational license reform in Georgia. Nurses are vulnerable and at risk because of numerous challenges, including a compromised mental and physical well-being, violence in the workplace, increased workload demand, demanding working conditions, bullying, lingering concerns about COVID, and not feeling valued, respected, or heard. Occupational license reform provides an opportunity for the nursing profession to benefit from untapped talent and to support and retain the nurses that we already have in our profession. We support occupational license reform because it is important to find the right balance in reform. Nurses are vulnerable and sometimes make poor choices, then seek help to change their situation. People make poor choices and deserve a second chance at turning their life around and entering the healthcare field. Just as David spoke today, which we would love to have someone like that in the healthcare field. Employers need support and guidance in retaining excellent nurses who have made a mistake. Occupational license reform can contribute to making Georgia the best place to recruit and retain nurses by increasing career mobility and economic liberty. This is an opportunity to support nurses and those who want to pursue a career in healthcare, their families, and their communities. Thank you for allowing us to speak today, and we hope you will pass the bill.
Thank you for being with us. That's all the speakers that have signed up. Would you like to close, Chairman Strickland, or are you ready to see your fate?
It's great to have so many groups represented, different backgrounds, supporting the bill. That's great, but obviously Mr. Johnson's testimony is what it's all about. So I appreciate his bravery and coming up here and testifying, and I appreciate all those that have worked over the past 6 months on this issue with me and others. I just get to be the face of it sitting up here today. So I ask for your support. Happy to answer any other questions that y'all may have.
I don't see any questions, so what's the pleasure of the committee? Hang on. We got a motion to pass and a second. Chairman Watson, do you have a question or proposed amendment?
I have a little of both. Mr. Chairman, I too applaud David and would love to have him, working in the state of Georgia as a PA in the health profession. I'm a little perplexed at the 3 to 5 year data relationship of recidivism, because my experience has been, and I've taken care of physicians, been in the program relating to drug abuse, and as a matter of fact, I've had an unfortunate situation where I advocated for them to get off at 4 years, and they they had a relapse after about 6 years, and that was very unfortunate. Not practicing medicine anymore because of that. But having said that, I again applaud David, applaud your groups, applaud the work, and I agree with your legislation, and I agree that we do need to allow people to work, especially, and give them another chance from that standpoint. If it's 3 to 5 years, would you make me feel better, and I'm not sure the whole committee will go with this, but if we change the 5 years to 6 years, because if we're saying, and I haven't, even though I applaud you looking at the data, I have not seen the data, and I don't know. I would love to see that. And if we're happy with 5 years, then I would be more comfortable with 6 years. And I'll tell you, that's my personal experience also, and I admit a bias that I have relating to my dealings in taking care of physicians in programs. So that's sort of where I am. It does seem to be a little bit uncharted in that a lot of states have done it around us. I'm not sure that we have been long enough to show that that is the right thing to do. I do think it is the right thing, and I think this committee will support that. And that's where I would offer an amendment to change the 5 years to 6 years, and I've outlined at least a dozen places in the bill for that.
I don't have any objection with that. I think, I'm assuming with Ledge Council, we can just give guidance to changing the 5 to 6, as will be multiple places in the bill. And that would be everywhere that it's 5, I'm assuming, when you're looking at the completion of a sentence, you would change that to 6. Is that what you're saying?
That's correct.
Is there a second to that amendment? Got a second from Senator Hodges. All right, all in favor of the, we got a comment, Senator Setzler.
Just clarification. So, to the author, what effect do you see that as having on the bill? I know we talked, the reference was made 3 to 5. Would this be a hard 72-month from what point until what point are we talking about? Just to understand the effect of what we're doing.
To be honest with you, it's hard to know, because we can sit here as we do in a world of theory and say, what's one more year, right? And that's me sitting here now saying go with 6. But that would be one of the year offenses that will be looked at as individual cases that may affect someone differently. I think to be honest with you, as I said to my friend Senator Watson, I think we're using an extreme example, and we're getting ahead of the fact there are other things that boards look at. We're talking about just offenses, just criminal records. What are we going to look at here? And so if you want to go to 6, it doesn't bother me, but you won't know the true effect of it. I believe other states, and someone tell me if I'm wrong, have done the 5. I don't think we pulled that out of the air. But right now we have no guardrails on that at all.
Yeah. So, I mean, and just, Mr. Chairman, and I'd say to the author, I get the author's thoughts on this. I mean, I appreciate Chairman Watson's thoughts. You know, all of us approach this a little differently. I mean, 5 years versus 6 years. To me, I'm probably more okay with 5 years. I might want a little bit tighter strike zone on some of the other issues. I mean, the standard of, I would call it the standard of review, I guess, that we're establishing here, by which these things are compared. That probably concerns me more than the 5 versus 6 years. So I'm not going to offer an amendment. I'm just saying to the author, I would like the author's thoughts on it. I can probably live with 5. I want to express for the public. I think the public interest in this is very, very noteworthy. I think we need to move in this direction. In supporting this, I want to express my considered caution what we're doing. I'm going to support this. But I do think there's some concerns about how this is implemented by the boards, and I think I do think we need to watch this and make sure boards, we give this very narrow strike zone, if you will. We're narrowing down the circumstances by which they can deny somebody they might have some legitimate concerns about. I hope in implementation there's a bias towards the boards applying their judgment in interest of public safety. So I'm prepared to the authors. Would you prefer 60 months versus 72 months?
I wrote it with 5 years, so if you ask me to do it at the same time, I'm not. So if I want the bill to pass, if it makes a difference, if it gets more yes votes in the bill, then I'd say go with 6 years. So it's your call.
Any further discussion on the proposed amendment? All right, all in favor of Senator Watson's amendment extending the time period to 6 years from 5, wherever that's referenced in the bill, raise your hand. We've got 3 votes for, all opposed. Chairman, you get to vote. Which way you going to go?
Well, if I don't vote, then I get to. Or would you vote?
If you don't vote, the amendment fails.
Right, I'm not going to vote.
If you vote in favor of the amendment, it's a tie, and I might get a vote under that circumstance. If you don't vote, I could also vote to create a tie, though, and your bill will fail. So I just want to give you a chance.
Yeah. I'm going to not vote and leave it as it is. Take my chance.
All right, the amendment fails. I'm not sure of this committee's rules.
I think you can vote to create a tie, but you must vote when there is a tie.
Chairman, if you're a member of the committee, then you got to vote.
Oh, he has a member of the committee. That's right. Yes. So I vote no.
Okay, the amendment fails. All right, back to the main motion do pass. Any further discussion? All right, all in favor, please raise your hand. 1, 2, 3. It appears to be unanimous. That will move on to the Rules Committee. And you are welcome to come back and resume your chair up here. Yeah.
You forget how much easier it is to sit up there. All right, Senator Cowser messed my stack up here, so I'm all out of whack. All right, we're going to go back on the agenda. 2 more bills left. Senate Bill 182, Senator Halpern. And with this, we're working off a substitute LC 480892S. And if you'll just introduce those that are sitting with you, I think both of them signed to speak on the bill, too.
They did. It's probably easier for you to go in this. Thank you
I'm
so
bringing
much.
another chair. You're good.
Thank you, Mr. Chairman and Committee. I have with me Attorney Otto Ekpo from the Office of the Fulton County Solicitor General and Mr. George Jenkins. He's the ED from the Trial Division of the Fulton County District Attorney's Office. And so I will not be long, but this bill, and there is the substitute, as you said, this bill really deals with the issue of doxing, which is a type of harassment. It's slang for dock dropping or dropping papers, but doxing is the process of collecting and then making someone's address, contact information, identity, or other personal information public, usually in order to intimidate, harass, or incite public outrage or stalk them. And this is what inherently distinguishes it from existing cyber stalking laws. It's the collection of info and then deciding what information to reveal on which platform and the method of revelation. There aren't clear statistics on how many people have been doxxed, but a 2021 report did reveal that 43 million people, or 21% of Americans, have experienced doxing personally. And doxing creates harm offline in the real world because the personal information posted is accessible to anyone with an internet connection. And once that personal information is on these public sites, it's available for anyone to view and use, and it is very difficult to remove. Doxing's harms include harassment, physical harm, and financial harm. And doxing victims are also at an increased risk of identity theft. In response to the growing number of incidents, the GBI has launched several initiatives to raise awareness and to help prevent further doxing. As the law often has to play catch up with what's happening in the real world, in recent years, state legislatures have begun passing laws to combat doxing that make it illegal to distribute personal information obtained through unlawful means. And so far, states have generally taken any combination of three approaches. Laws that allow victims to sue doxers, laws that make doxing criminal, laws that protect certain groups of people, for example, specifically police officers or healthcare workers, and journalists and elected officials are increasingly targeted as well. This particular bill really focuses on the first two approaches, and it in the substitute, it adds language under the stalking code section that's already in Georgia code, defines what doxing is, explains about social media, which is generally where we're seeing this happen, and talks about the kinds of effects that it can generally have on the victim of doxing. It then goes on to set out and establish that it is illegal. In line 36, D1, a person who commits the offense of doxing shall be guilty of a misdemeanor of a high and aggravated nature. And it also, because of code already exists on stalking and temporary protective orders, it also references back to there in line 34. It does provide for a course of civil action for victims of doxing. And the one thing that didn't make it into the substitute that I might offer for your consideration is to add in that a venue provision, the venue can either be the place or places from which the communication originated or the place at which the communication is received. But it is a fairly simple bill, just looking to establish for Georgia the fact that we recognize doxing, we recognize that it's increasingly happening, and that we want to recognize it specifically in our code, since the cyber stalking and cyber bullying laws that are already on the books don't really speak to the full nature of what's happening and the impact on the victims and their recourse as victims themselves.
All right. Do y'all, either one of y'all want to say anything right now?
I'll let my colleague, the Solicitor's Office, start, and I'll follow.
Okay.
Thank you. Good evening, everyone. My name is Oto Ekpo. I am the Director of Advocacy and Compliance from the Fulton County Solicitor General's Office, and I appreciate Senator Halpern for inviting me to be here today. I don't think that she really left much meat on the bones for me to add, but I will say that we have an opportunity with this particular bill to be more proactive rather than reactive. We know that Gen Zers are always in the social media, and the way that they are using social media to harass people, it's completely different than what we would have imagined 20 years ago. And so this is an opportunity that if this does pass, for us to be have a preventative measure to be more proactive rather than reactive. And I can answer any questions for those that may have some. Thank you.
All right, we do have a question. You want to go and ask your question? Senator Hatchett.
Thank you for bringing this. I just want some clarification on, I guess, what a violation of this code section would be. I think it's common now where we'll see someone get angry with another person, especially an elected official that may have communicated with them via text message or email. They'll screenshot those text messages and email. Maybe they might cherry pick certain parts of the conversation and put those on social media and put them on blast. Is that something that would be covered in this bill, sharing the communications, I guess identifying who the person was, and it be like on social media?
So the intention is that that would not be an example of doxing. I think the characteristics of doxing really are that there is an intention, like a malicious purpose to them putting that out, specifically meant to intimidate you, harass you, threaten you, or get other people to do the same thing. And it's not so much information like what's in a text message, it's really more personally identifying information. So it would be your address, it would be your children's school, it would be that they have combed information specifically to find personal information about you to put out onto the internet. It could be social security numbers. It could be bank account numbers. It's really meant, the intention here is to capture personally identifying information with the intention of doing you harm.
Okay, thank you.
Senator Sessler has a question as well.
Thank you, Mr. Chairman. I got, love the concept. Got a number of technical questions for you. And I want to get in the nitty gritty if I can. First question, we use the term social media, and this may be a stylistic thing. I went through this. This wouldn't have any effect on the applicability of the bill. I'm concerned social media platform is a term we're using in 2023. I'm afraid it, even though we define it here, means website or computer application design. I wonder, parenthetically, should we call it automated platform? Because we are contemplating not through mail. We are thinking about through a computer, but social media tends to have a specific meaning that this definition's broader than. Automated platform will have a broader definition I think is more consistent with yours. I just say that as a consideration. Secondly, the on lines 29 and 30, the knowing, so you have the knowingly element with the purpose to frighten. Is there a reason we didn't use intent to frighten? Is intent and purpose, is there a different color of that? You guys who prosecute, litigate these cases, is there a difference there that's important to us to understand?
I would say that you would be right. I think intent would be the most appropriate language to use, as you see that all the way throughout the code section. So if you look at line 16, where it says malicious purpose, it is a specific intent. And so I think characterizing that as malicious intent would be more appropriate, and then also pairing that with line 29, as the senator, with the purpose, with the intent to frighten, would be more appropriate.
Okay, just asking that question. Thank you. Line 30, the big "and" has got the big circle in my page around it. So both 1 and 2 have to be present in this. Okay, help me understand, and I'm just trying to understand this. I'm trying to help you, I think. Causes such identifiable person to be in reasonable fear. Causes to be in fear. So you've got to demonstrate not just there was intention to create fear, there's not just an intention to create intimidation. Why would we have an element that says, I was actually scared or I was actually fearful of it? I mean, it seems like the intent to create fear through these actions, why would we add, should be enough. Why would we add, oh, by the way, why would you want an element to show that you actually caused someone to be in reasonable fear? Not unreasonable fear, but reasonable fear. I mean, how would you want to have to prove up that you actually caused reasonable fear?
Now you're asking me as a prosecutor? Absolutely not. I want something that's easier. But I think that the way that it's written, there are so many instances where people are using social media on a daily basis, and I think that it is appropriate to use the word reasonable, because there might be an intention where someone uses it, but it's not actually causing a reasonable fear, if that makes sense.
It's out there. It's only because you're maybe unreasonably sensitive to it that you have this fear that you don't want that to be able to give rise to.
Correct.
Okay.
I think it limits the amount of cases that we would have, because you don't want it to be too broad, but you also don't want it to be too narrow. Would you agree with that?
Absolutely.
If I could, Mr. Chairman, one last question. On the venue, I love the venue provision, originated, received. Would you not want to also have a venue option for the address of the victim? So let's say there's somebody transmits it from California, it's received in North Carolina or in downtown Atlanta or whatever, but let's say I'm a victim, I'm in Cobb County, I want to have this prosecuted in Cobb County, and I'm the one that's in fear, I'm the one that feels the effect. Should the victim's address, whatever that means, they could be, but should the victim's location or address not be a venue? If I wanted to have this prosecuted in my own circuit, should I have to go to California? No. Should I have to go to Savannah where it was received, or Atlanta, or should I be able to? So I'm just parenthetically, should I be able to, in your thinking, have it in my own circuit
I
as a
think
victim?
the venue provision, the way that it would read would be, can be either the place or places from which the communication originated or the place at which the communication is received. And would that not encompass both if you're in California and if I do some type of swatting, for example, I send the police out to your house in California, I put your address out in California.
Well, Senator Halpern, which county do you live in?
Fulton.
Okay, so she's in Fulton County. If someone in Cobb County doxed Senator Halpern, and it went all around, and people were they're trying to get people from outlying counties. Hey, we don't like Senator Halpern. She did something in whatever it is. Should she not be able to bring the case in Fulton County?
She absolutely should, Jeff. She absolutely should.
No, if my doxing though is not sent to Fulton County, it was sent all around, sent other places in the state. It would still seem she should be able to bring the case in Fulton. Is all I'm saying.
And so, in the places where it says which the communication is received, would that encompass what you're thinking of?
The place the communication is received, or the address of the victim. I just think the victim ought to be able to bring this in their own circuit. I just would offer that to you as consideration.
While you're on that point, the only thing to think about is whether or not the crime actually was committed in any way, if it's just the address of the victim. That's just one thought. Because you're saying the receiving part you're talking about is the original receipt of the document that then is shared, right?
It could be in either place. So if you are in Cobb County and the senator is in Fulton County and I send a communication out publicly, you receive it while she's at her house, then you could either be Cobb County or it could be Fulton County.
I'm just saying that her receiving it, the damage done, the doxing, is the fact that 10,000 other people received it.
Yeah.
You sent it all. Let's say you sent it to the hinterlands in a far-flung congressional district of Georgia, and you're trying to bring, some kind of intimidation towards the senator. It's been the focus of the receipt was not her home in Fulton. It was the places where the others would be.
Then yes. Mm-hmm.
So.
All right. I believe you wanted to speak as well, Mr. Jenkins.
Thank you. Chairman Strickland, good to see you again. And committee members, very briefly, just like as I stated, and Senator Halpern, thank you for this legislation. Just like anything in Georgia, I've been a prosecutor here for several years, and I think that, first of all, this is a growing problem across this country, and we need to get ahead of it. And as such, I can tell you if it's going to happen, it's going to happen here in Georgia. And so I want us to be prepared for such activity. And I am worried because I do prosecute the crimes in which identity theft and fraud are rampant, and we've been dealing with those issues for years. I can tell you that these doxing, and I'm certainly no social media expert or an internet expert, that's just the truth of it, but I can tell you that the wide dissemination of someone's personal information attracts not only the people that are interested in that conduct, but it attracts bad actors, those people that want to use that information for criminal activities, individuals or crime organizations that we have here in Georgia, whether they be criminal street gangs or your traditional organized crime outfits here. And so I think that we need to address it. The community needs to deal with it, and we need to get out in front of it across this country, certainly here in Georgia, because if it's going to happen, we need to prepare for it. That's all I got to say about it.
All right, thank you. Any questions for the author, Ms. Ekpo or Mr. Jenkins? All right, thank you.
I want to add that I did work on this bill with the Prosecuting Attorneys Council, and I don't have a letter for each of you, but I do have a letter of support for the bill from Frontline Conservative Business Alliance, and I know that we've got somebody who has been a victim of doxing here to actually address the committee as well.
Okay, a Frontline Policy Council sent a letter that didn't quite make the folder yet, so you're referencing support in the bill. Yeah. Was that Melanie's Ford? Is that the person that was going to speak?
Is.
Okay.
Yep.
Do you want to come on up? Good evening.
Good evening. I'll also be brief.
All right.
And be easy. I'm a newbie.
That's okay. I tell you, it's easier to sit right here than it is right there. I know that.
I want to thank Senator Halpern, and I want to thank you all, and I will try and be very, very brief. Unfortunately for me, I am a victim of doxing. It originally happened to me in 2016. There wasn't a word for it that I was aware of. I have since, I've lived all over, but I've since returned back home to Georgia, and unfortunately my doxer is in Georgia. What happened to me is I went online and purchased a cookbook from a person, left an honest review, and that person didn't like it. And as a result of that, that person has sought me out. And I brought boards and wanted you to see some of the tweets, but it's been a long evening. I won't put you through that, but it's pretty bad. And unfortunately, this gentleman, and I'm being kind, has a history of doing this and has done it several times. He's been a 3-part series with Randy Travis here in Atlanta. His name is Darius Williams, doxing people. He's doxed myself. He's doxed underage children. He's put children online. And when you go to these social media companies, they don't do anything. Sometimes they may send a warning, but it's a whole nother thing, and I'm sure you all are aware of that we won't get into this evening. Proposal 230 kind of protects them, and you have people out here like Mr. Williams who are doing things like putting my car, he found out where I lived, he put my car online with my tag number and it said this, and my car is distinctive, it's a distinctive car, it's a distinctive color, and put online with a picture of me and my husband that this is the car that Melanie Ford uses to ride around Atlanta for finding little boys for her husband to enjoy. My husband is the Chief Human Resources Officer for one of the largest employers in Georgia. And I have had, my parents are here this evening, and that gentleman put up their address, and I've had people to come and say that they were going to come and F us up, and F us up is not what was used. They were going to hunt us down and F us up just because this gentleman chose to put things online about me and my husband that was not true. He has a massive following on all platforms on social media, TikTok, Instagram, Facebook, Twitter. He has close to 3 million followers. I am not a social media user like that, so I could not combat. And what I'm finding, and it's a horrible situation to be in. And I would dare say, I would think that if you are not, if you have not been doxxed, or if you've not been cyberbullied, there's someone that you know or that you care about that has, and unfortunately probably will, feel the effects of this, because this is a type of cyberbullying, cyber harassment. There is no reason for anyone, because people like him can go and spend as little as $9.99 and get a background check, and I can get Senator Parent's previous addresses, if you have children, where they go to school, and post that online, and there is nothing that she can do because I have Second Amendment rights. Now, you can sue me, but then that could take years if I said something wrong as far as defaming you, but there is no outlet right now to make me take that down. I'm at the whims of, or you would be at the whims of, if I fill out a form on social media and I wrote to Twitter and wait for them hopefully to respond to take this information down. It's been a horrible situation for me, and I have done a lot of research, and this is impacting people. Most people seem to think that cyberbullying is kids because it's juvenile, because it's a juvenile act, but you have adults, and I'm sure you all have seen some things where there seems to be some people that wake up and just want to get online and be horrible to people. But this is dangerous. Doxing is searching out public information, private and personal information, and putting it online. And what's key here is with malicious intent. And they are doing this to hurt people, and it's dangerous. I don't like, even if I filled out a form, and like you can find mortgage records, and my information is out there, I don't want my address online for all the world to see. My doxer has put up social security numbers of people, home addresses. Again, underage children. And if countries like the UK, India, Japan, Germany can come up with laws to protect its citizens, surely Georgia can. I'm born and raised here, Marietta girl. I don't think this is right, and there's got to be something that we can do to get ahead of this, because this is dangerous, and this is going to get someone really, and it's gotten people really, really hurt. So thank you for your time. If you have questions for me, I'll gladly answer them, but that's pretty much it.
Thank you, Ms. Ford. Thank you for being brave enough to share your story and bringing your family here to share their story as well. You do have one question from Senator Hatchett.
Okay.
Thank you, Mr. Chairman. I know the hour's late, but I want to take our time on this. I appreciate this bill, and I'm sorry for what has happened and that you didn't have a legal vehicle to go after this guy. Something you said bothered me just a little bit when you said that this guy has gone after minors.
Mm-hmm.
And I know that it's terrible what's happened to you, but if people are doing this, if adults are doing this to children, I think that's even more egregious. And wanted to see if the author or someone in the audience would be open to an increased penalty for an adult doing this to a minor.
I would agree.
Okay.
All right, you have no other questions.
Okay.
Thank you, Ms. Ford.
Thank you. Thank you all.
We have one or two others signed up to speak that are going to come together. I'm assuming Ms. Maisie Lane Girton and Arturo Corzo again, the Georgia Association of Criminal Defense Lawyers. Good evening.
Good evening.
Welcome back.
Mr. Corso is going to lead the charge this
All right.
So, first of all, I agree with Ms. Ford that something needs to be done, and I agree with the author of the bill that a good way to address it might be to add some specific language about doxing. However, it is not the case that what happened to Ms. Ford could not have been addressed by a vehicle. Everything that she described is prohibited by an existing law under OCGA 16-11-90, which prohibits stalking. 16.590, which prohibits stalking, and then 16.539.1, which prohibits harassing communications. So if Ms. Ford was not served by her prosecuting agency, that's a real shame, because there are laws and have been laws in place to prevent exactly that. And I think that person, to politely call him a gentleman is very forgiving. I'll call him a scoundrel. That scoundrel should have been prosecuted to the fullest extent of the law. However, as an attorney, I look at this particular proposed language, and I did have the pleasure of speaking with Senator Halpern this morning about trying to address some of the concerns. Here's my concerns. Number one, we're creating a new crime altogether, and it's 16.597. This really would be better placed under the existing stalking statute as another type of stalking. If you look at 16.590, there are two ways to commit stalking. One is by following a person, surveilling a person, or contacting a person with the purpose of harassing and intimidating that person. That's already a misdemeanor. That's one way. Part two of stalking is to do so in violation of a TPO or a bond order or any other restrictive type of order. So this could be, doxing could be a good third way of committing stalking, and that's why I would suggest putting it under there. Secondly, in this draft of this bill, we've got some conflicting definitions. If you look at the proposed lines 15 and 16, doxing is defined as transmit, send, or publish private or identifying information. But then on line 27, we have a different definition of doxing. So for this bill to really do what it's intended to do, we would need to see some parity between the language. For example, and I think Senator Setzler already pointed this out, line 27 and 28 has the word knowingly, whereas line 15 and 16 does not. The bill also has a particular concern when it comes to the type of offense created. The existing stalking rules are misdemeanors to violate. This would create a high and aggravated misdemeanor version of stalking, which is, or they call it doxing, but it's a version of stalking, which means that when you serve your penalty, you're not entitled to good time credit. So if the judge gives you 90 days to serve, you would serve 90 days and not get what we often see as 2-for-1 credit. But more concerning is if you look at line 38 through 40, it's talking about how doxing is a misdemeanor, but if an offense results in serious physical injury to the victim or the victim's immediate family member or household member, then it's elevated to a felony. So the way this bill is currently drafted, if I were to, as a scoundrel, dox a person, but then a third person comes and uses that information and does injury to any member of their household, I've now gone from a misdemeanor to a felony because of the conduct of a third unrelated person. And that's a real concern. I can answer questions, but given the hour, I'd like to go ahead and cut it off there. This is a bill that probably could be made really good if we were to hold it and send it back and spend a little time working on the language, and I'd be more than honored to participate in doing that.
All right, thank you, Mr. Corso. You do not have any questions.
Okay.
Before we leave, though, I would like to just quickly add that another distinction about this bill from what we see in other states that have criminalized doxing to date is this idea on line 15 of private or identifying information. That's undefined in this bill. And it also doesn't require, for instance, more than one indicia of identifying information. So for instance, if all you're requiring for identifying information is someone's name, and we know that names can be common or not, they can be common names. It's vague. By leaving those terms undefined, you're opening the door to a vagueness challenge. One of the things that we are not, as criminal defense lawyers, schooled in, like some of our colleagues, is the First Amendment. And we did reach out to a couple of First Amendment practitioners who were not able to join us here today, who do have some concerns about it is not. Sorry, my vocabulary is leaving me.
It's just when you're dealing with a public figure, there's an elevated First Amendment slander standard that requires malice, whereas that's not required in First Amendment free speech limitations for non-public persons. So if you're a legislator or a movie star, and I think those terms can be used interchangeably, then
just for one in the back, I think.
This is another area in the bill that I think we should try and address is not just saying, hey, we don't mean to step on any free speech rights here, but actually address public figures and what it means to reserve your right to criticize with pure political speech and not get roped into a felony doxing by the conduct of someone else. To be as controversial as possible, it makes me think of January 6th, where you have one person speaking and others acting. And I'll just leave it there.
And that is a distinction even in what Ms. Ford described. There was a part of her description of her unfortunate experience that was where the doxer was inciting others to act, which if the language of this bill was more clear about that, we wouldn't have as much to say about it. But this is not requiring any kind of inciting of behavior. It simply is a communication of this broad private or identifying information. There are some doxing laws on the books that are more specific about the fact that the communication does need to incite that third party to act, which then would also take the wind out of Arturo's sail about being upset by the enhanced penalty in those situations, because you would be on notice that if a third party were to be incited to some other bad behavior, you as the original actor would then be subject to felony prosecution.
Senator Sessler, 10 seconds.
Yeah, keep it short. I will say to your point about, in other actions simple doxing and that you're accountable for other people's actions. That's the nature of this, though, is some subtle, oh shucks, here's some information about them, oh, maybe harass them. But the subtext of all this creates threat, creates almost an invitation to do things. That's the subtlety. And I think that's why we're maybe handling this differently.
Yeah, and if the person is doing it with that intent to incite a third person to act in a violent manner, we might be having a different conversation, but that's not in the bill.
Well, proving that intent may be difficult, but if the effect is, prove that I meant this, you put it out there, and then there's actual, you're inviting actions against a person that's real, that's a thing.
Yeah.
All right. Thank y'all.
Thank you.
Sure, thank you.
That's everyone that signed up to speak on the bill. What's the pleasure of the committee? Motion to pass by Senator Rhett. Do we have a second?
Second.
We have a second. It's by Senator Setzler. By committee substitute, Senator Setzler. Any amendments?
Hey, Mr. Chairman, these are things that I shared with the author, and
Let's do it one at a time.
Should I do it one at a time, or all as one whole, or what do you think, Mr.
Let's do one at a time. I think it'd be easier.
Okay. Mr. Chairman, let me do this in this order then. And on line 17, I know anything inside the parentheses, whether it's social media platform or automated platform, for the purpose of this code section, we could say anything. We could use any term. I was going to offer to remove the word social media and replace it with automated, so it would be automated platform. Just because in the plain reading of this, even though as it applies there wouldn't be a strict difference, automated platform I think is broader than the conventional understanding of social media, and I think social media has an effect in the minds of whether it's jury, whether it comes to take on a meaning of its own. I just think the word automated platform conveys the breadth of the definition that's in line 17 and 18. So I've got an amendment that would replace social media with the word automated, and that would cascade through 2 other locations in the bill.
So before we do that, let me ask Ledge Council, do you have any comments on that potential amendment? Okay.
No legal consequence, no change.
Does the author have any desire they want to express on that amendment? Do you want to step back up? And you can.
I'm completely fine with changing it. I think what we were just saying is automated platforms, not a term that we've heard ever before, where social media is more understandable. At least you're right now in 2023. So I don't know how to resolve those two, but automated platform.
Because a website is not social media. A website's not social media,
Right.
and email's not social media. I could
Right.
send an email out. I could send an email blast out that doxes people. It's not social media. And I don't want to get in a sense of what social media means and doesn't mean. Electronic platform?
Electronic platform.
Whatever pleases you. I'm just trying to
That'd
accomplish
be
your
great.
goals.
Electronic platform.
Electronic platform.
And
All right.
And I did notice, I think, a Scribner's error, actually, when the criminal defense lawyers were talking, because I think on line 9, I think it should say 16-5-90, because that is the code section.
Is that correct? Paul, you mic 3?
So, Chairman, I did not draft this, but the way the directory language reads is that the intent was to create a new code section, not to place this in an existing code section. That can be done, but from a drafting perspective, that takes some time. And legally, in my mind, it doesn't matter where the language is. That's more of a...
So we could give you some guidance to fix that potential issue if it needs to be fixed?
Yeah.
Okay.
That's fine.
So let's back
Leave
up.
it as it is for the-
Okay. So
I said that.
the current proposed amendment is to change the word social media to automated. What was
Electronic.
Electronic.
It would be
Is that
electronic platform on line 17, line 29, and then on line 16, where it says information about a particular person on social media, it would say on an electronic platform. So those are the 3 places that exist in the bill.
Do we have a second for the amendment? We have a second. Yeah, it's discussion. Senator Hatchett.
To the author of the amendment, would you be comfortable saying social media platform or other electronic platform? Because I do think social media pretty much explains itself nowadays.
Well, electronic platform means a website or computer application designed to facilitate the communication between one or more persons. That is social media. I mean, social media is clearly included within that. Websites included within that. A blog is included within that. An email is included within that. It's intended to be any electronic communication.
You want to offer an amendment to the amendment?
I mean, I'll restate the amendment if it doesn't please the committee. I'm just trying to broaden this sufficiently, because I think.
So I think that
Go ahead.
the or statement, I do think does that. Because it captures exactly what you're saying, and it also captures social media, which is something that is in our consciousness today. And if it doesn't stay in our consciousness, then the electronic platform definitely captures everything else that
I'm
you're
hearing
intending for us to.
Senator Sessler agree that he wants to amend his amendment, so it'll say what Senator Hatchett said. So it'll say.
It will say on lines, essentially, I will within the parentheses on line 17 where it says social media, it'll say electronic or social media platform, all in parentheses. And then the same thing will apply on 29. You would insert electronic or before the word social media. And then on line 16, it would be an electronic or social media, and you would insert platform after that. So that definition doesn't, you're not using the definition 16, it's a miss. I think you've got to have platform after, so that definition follows. But that would be the first Sessler amendment.
So Senator Sessler has withdrawn his first amendment and now asserted this amendment. Is there a second for this one? Second from Senator Hatchett. Any further discussion? All those in favor of the amendment, please say aye.
Aye.
It carries unanimously. Senator Sessler.
Second amendment would be getting to speaking to council, the word intent versus purpose. I would replace the word purpose on line 16 with intent, and I would replace the word purpose on line 29 with intent.
All right, we have a second. Second from Senator Jones. Any discussion? All those in favor of the amendment, please say aye.
Aye.
It also goes unanimously. So, Senator Sessler, do you have one more?
Just the last one was, and this is however the author wants, the author had an amendment that related to venue. Do you want to read that? I'll put that in the form of a motion. Or did you have that already prepped?
No. So what I said, but then we had that whole discussion. What I said was venue can be either the place or places from which the communication originated or the place at which the communication is received. But then we talked about the venue option for the victim. So
I was going to state as the lady just read it with the addition of the words or the address of the victim.
So for
or place of
Paul,
place of residence.
Let Paul speak.
Chairman, I think my preference would be to say or county of residence of the victim.
Okay. Paul, do you have any language that we would use typically for venue that you could share with us?
I know we have language. Off the top of my head, I don't know that I'd get it perfectly right, but it's pretty standard language, and I could make that happen.
Is everybody on the committee comfortable moving forward with the amendment, knowing that Legislative Council will put standard language in that will match the intent of the author of the amendment? Does anybody have any concern with that? Okay, is there a second for the amendment? Second from Senator Watson. Any discussion? All those in favor of the third Sessler amendment say aye. Aye. It's also unanimous. All right. Any other amendments? Senator Hatchett.
I'm not sure where we would put this. I'm assuming it would be after line 37, and I'll defer to Ledge Council on the exact wording, but I'd like to say a person who is an adult under the law that commits the offense of doxing on a minor shall be guilty of a felony.
All right, let's see if there's a second first. Is there a second for the amendment? No second. There's a second for Senator Jones. Discussion, Senator Setzler.
I wonder if structurally, if you want to just take the subparagraph or paragraph 2, line 38, where it talks about serious injury or second and subsequent, if you wanted to add to that list serious injury, second and subsequent, or any adult that acts on a child.
Adult that acts on a child.
Would that be easier just to put that in as the third condition that would satisfy paragraph 2? Would that be a way to do it? Because it's a 1 to 10 felony right there.
Okay, that's
Paul,
as long as the penalty is heightened against a minor, I'm good. I don't have any.
Mr. Higbee.
Chairman, my thought was at the outset of this to just simply create a new paragraph 3 after line 41 and have this be a separate offense. I certainly could do it the way that Senator Setzler said. Just in my drafting mind, that seemed a little cleaner from my perspective.
Are you okay with that, Senator Hatchett?
I'm good with it.
All right, we have.
So the question is, are you suggesting a 1 to 10 felony, or do you want something different than 1 to 10?
1 to 10 is fine with me. Yeah.
All right, is everybody clear on the amendment? It's been motion and seconded. Any further discussion? All those in favor, please say aye.
Aye.
It also is unanimous. Any other amendments? All right, back to the interline. Motion to pass by committee substitute as amended 4 times, I think. All those in favor, please raise your hand. All right, unanimous again.
Thank you so much.
Thanks for your work. Is that all we have left, I think, or oh? Never gets old, right? All right, one more bill left. Senate Bill 201, Senator Estevez. We are working off a committee substitute, LC 442322S. All right. Give everybody a second to exit. All right, Senator Estevez, the floor is yours.
Thank you, Mr. Chairman. When they talk about freshman hazing, I did not realize that I would be here for the whole hearing. But I will be spending the next hour talking to you.
I sure hope not.
No, I'm kidding. Hopefully it will not be that long.
All right, hold on. Y'all ready? All right.
Fascinating discussions.
They're still rewriting the last bill.
7:41. I am here with friends that will be talking about bill substitute that you mentioned, LC 442322S. This bill seeks to address 2 issues impacting victims of human trafficking and is intended to give those victims justice and provide them with the opportunity for a fresh start. Before I begin on discussing the bill, I'd like to highlight a few experts that will be speaking to these issues that are addressed in this bill. One is Kamala Zulfagari, from the Executive Director of Street Grace, Emma Hetherington, who is the professor at the University of Georgia School of Law and advisor for the Will Banks Child Endangerment and Sexual Exploitation Clinic, Pat McDonough, who is an attorney who represents many of the victims of human trafficking, and Amelia Quinn, who's the Executive Director of Beloved Atlanta. As I mentioned before, this bill is seeking to address 2 issues that are facing victims of human trafficking. Sections 1 and 2 are seeking to address the issue, an issue related to vacatur. Current law allows victims of human trafficking to have sentences vacated. as y'all know, when a sentence is vacated, it's as if it never happened. However, current Georgia case law has found that when a person takes a first offender plea, it's not considered to be a conviction. Therefore, the ability to vacate is not an option for those survivors, for those victims. This bill would address that issue and allow for those pleas to be vacated and allow those victims to have a fresh start. This amendment would clear up the original intent, which was exactly that, to give.
He's also was throwing this last minute. He's not telling you that was not originally part of his bill. But he's correct. That's when we did the vacature law originally. I carried the bill originally as a full leader for the governor, and it applied after you finished your sentence. Well, as y'all know, first offender, you don't really have a conviction that ends like that. We went back and amended it sometime last year, the year before, and made it where you can actually apply during the middle of a sentence, which now you have people in this loophole that have a first offender sentence that never can apply for vacature. And so the senator has been gracious enough to work on that issue in his bill. It's the same subject matter as his original issue. So thank you for doing that.
Thank you, Mr. Chairman. So the first two sections of this bill address that. The next two sections of the bill address another issue that we identified on behalf of victims of human trafficking. This dates back to the 2021 human trafficking law that was a landmark law, a great law that was led by the First Lady, Marty Kemp. And what that law did was that it expanded civil recovery limitations for victims of trafficking to 10 years after the trafficking occurred, or 10 years after the trafficking survivor reaches the age of 18. So essentially before the age of 28 if they were the victim of human trafficking prior to the age of 18. When that law was implemented in 2021, it did not include a look-back provision, which is common for these types of changes. And what that did was it left out human trafficking victims who were 29, 30 years old, who had been victimized when they were minors. And as a result, they did not have a relief. So what this bill also does is that it provides for a 2-year look-back period to allow for those survivors to bring lawsuits over the course of the next 2 years. The bill would allow for those lawsuits to occur between July 1st, 2023 and July 1, 2025. I'll leave it at that, and I'll see if there are any questions initially, and then if not, allow the experts to speak more to these issues.
You picked a tough topic to try to make jokes about with you being a freshman, and it's late. And so appreciate your work on this. You don't have any questions at this time.
Right. I'm not sure my brain is working very well right now.
I'm not sure what I'm saying either.
Yeah.
So do you want to add anything?
Yes. Chairman Strickland and members of the committee, my name is Kamala Zulfagari. I'm the Executive Director of Street Grace. Prior to that, I was the Attorney General's Chief Human Trafficking Prosecutor, and before that, I was Fulton County's Human Trafficking Prosecutor. And coming from that law enforcement background, I would say this is not an issue that we will just arrest our way out of. However, this committee has, in the past, made some great changes to our laws, both in the civil arena, in the vacatur arena, and in the criminal arena, and we are the envy of so many other states. There's been a great increase in prosecutions and identifying trafficking cases, not necessarily because it's rising, but because as a state we continue to shine a light on that, and we're so grateful for that. The Urban Institute, in a federally funded study, estimated that the underground illicit commercial sexual economy in the metro Atlanta area is $290 million. Trafficking is all about the commodification of our most vulnerable, about buying and selling the vulnerable, and it's about money. The vulnerable are treated like a renewable resource. You can sell those drugs one time, but you can sell that child over and over again. And I will leave it to my colleagues to talk more about the civil side. Chairman Strickland, you've carried both of our the vacatur bills in the past. This is just something when we opened it up last year that we missed. And so we're having cases, numerous cases in counties where prosecutors are agreeing to vacate the convictions of those who have convictions because they have multiple convictions. They didn't have first offender status. But they're having questions or not being willing to vacate when there is first offender status because there's nothing yet to vacate. So I think we should all, understand that this is the person who only has the one crime, they have the first offender status, and we don't have the law. So we're really thrilled that Senator Estevez has been willing to work with all of us to bring this. And if we don't have any other questions, if you have any questions, I'm glad to ask. And if not, I'll turn you over to the civil attorneys.
All right. Thank you. All right, so I think you introduced everybody already. I have Amelia Quinn, Pat McDonough, and Emma Hetherington all signed up to speak. Does anybody want to go first, or?
Good evening. I'll try to be brief. Just real quickly, I was a prosecutor in my previous life, but all I do now is represent survivors of trafficking. And I wanted to just say a couple really quick things. Is the statute that y'all passed to allow survivors to actually have a cause of action, it mimicked the federal statute that they had passed back in 2008. And it is a fantastic statute, and you're to be commended for that, and the governor's to be commended for that. But the reality is, I would say probably I'm involved in 90% of the cases that are filed in the state of Georgia, and there's not a single case that has been filed under that statute. Because the truth is, when you're sex trafficked, you deal with complex trauma. And you get out of it, you get rescued, you go to a wonderful rescue organization, you finally start coming out of this, and then you have an ability, and you realize, hey, maybe I could file a lawsuit because this hotel knew all about what was going on, and I should be able to do that. If you give this look-back period, you will now allow those people to do it. If not, the likely chances your bill will be wonderful, just like the federal bill is wonderful in about 5 or 10 years. All of my cases are filed in federal court because we have a 10-year statute of limitations in federal court just like this, but it went into effect in 2008. Yours went into effect in 2021. So you have to be trafficked, get rescued, and then decide to do that. So if you pass this look back, I think maybe the most important thing you're going to do is you're going to allow survivors to actually go before Georgia judges, Georgia juries, the people that were elected and appointed by the governor in this body. The second thing it does is it does give, and I don't think it will be a lot, but I met a young mother who's 30, and she just missed the federal statute. I mean, she's got 2 kids, she's got a full-time job, she's doing wonderful, but she has missed her ability. She's a little outside of the 10 years. She was a 16-year-old when she was trafficked at a hotel. And this would give those people an opportunity that missed the federal statute, also an opportunity to file that statute. The last thing I will just say to keep mine kind of to the point is I just want y'all to know I'm involved in all these cases. I'm happy to talk to anyone afterwards. This is not a case where someone snuck around the corner and a business got taken off guard. These are hotels that their businesses are literally part of their business model is to allow the selling of children and sex trafficking victims. I'm talking about 10 people at a time. I'm talking about depositions of people that say that they called their vice president of operations and said, hey, I've got these 13-year-olds that are out here getting sold for commercial sex. What should I do? And their answer from corporate was to move them around to the back so they can make money on both sides. So I applaud you for the work you've done. This look back would be a tremendous benefit, not only to some people that missed the federal statute, but it will actually give legs to the statute that you passed. And I can answer any questions, or I can turn it over to the next speaker.
A question from Senator Setzler.
What kind of accountability financially do these venues have? Is it asset forfeiture? Can they lose their? What's it look like?
They can't. Here's the reality: is most of them have insurance. So ultimately, what typically happens is that you've got an opportunity for the survivor if they sue the hotel. Most of mine are people that have hotels that are right off the interstate because buyers can come in and out very quickly. And so there's a real opportunity for them to get a financial compensation through insurance. There are times, we have some hotels that we're looking at that the conduct is so criminal, they're literally part of the trafficking operation. Insurance may be kicked out, and then we're looking at the assets and possibly shutting down the hotel. It's a long road in the civil world. And so I've been doing this since 2019, and we've had some great settlement successes where people have put their money with their trustee and have a financial planner, but we haven't got one to trial yet.
All right. No other questions. Thank you. I don't know who is going to be next. I'll let you all go.
Good evening. Chairman and members of the committee, thank you for having me here today and for inviting me, Senator Estevez. My name is Emma Hetherington. I am a clinical associate professor at the University of Georgia School of Law. I'm also the director of the Little Banks Child Endangerment and Sexual Exploitation Clinic. We're the first and only legal clinic out of a law school in the country that provides free, quality legal services to survivors of child sexual abuse, exploitation, and trafficking across the sexual abuse to prison pipeline. So everything from representing children in dependency proceedings in juvenile court who experience commercial and sexual exploitation, and also some civil lawsuits. We only file civil lawsuits against individual perpetrators. Again, we take $0. It's all pro bono work that we do, and we also do some of the vacatur laws. And I have to give a shout out to our lead litigator, Brian Atkinson, who is the brainchild behind the fix to the vacatur bill, because of a case that we got as a referral for a 16-year-old that has an adult conviction under first offenders. So we appreciate you hearing that, and I wish he could be here to talk about that. We have other things I just wanted to briefly mention. I'm a member of the statewide Human Trafficking Task Force, and I'm also a member of the statewide Sexual Assault, Child Abuse, and Human Trafficking State Expert Committee. I have been representing survivors for over a decade now in Atlanta and across the state of Georgia. In my research, I focus on what's called and I won't get into the weeds of this, it's not a law lecture, but I am a professor and I have to mention a couple of things. But to me, therapeutic jurisprudence is very important for survivors. And that means that our laws, the actors within our justice system, and our policies can have therapeutic effects on survivors. I cannot lobby as a employee of University of Georgia School of Law. I am not here to lobby. I'm not endorsing or opposing this bill. I'm just here to tell you what our research shows is best for survivors and what we see across the country. I can speak to a number of different things, but one of the main questions that I usually get about look-back windows is, are they constitutional? Short answer is yes. Civil statutes of limitations, statute of limitations in general, are procedural in nature. There is no fundamental constitutional vested right to a statute of limitations. In fact, the Cease Clinic, we represented a survivor in a case before the Georgia Supreme Court in 2021, Harvey v. Merchan, where the Georgia Supreme Court confirmed the very long-standing precedent that the civil statute of limitations that are retroactive, so this was for the look-back window in the 2015 Hidden Predator Act, reviving child sex abuse claims, the Georgia Supreme Court said, yes, that is in fact constitutional. Even if the look-back window in this bill were to be found to be substantive, so that would be a law that creates a right, a duty, an obligation. The question there is if that retroactive operation would take away or impair a vested right that's already provided under existing law, or if it would create a new obligation or impose a new duty. Under our criminal trafficking statute, which we've had on the books since 2006, there's no new duty imposed on corporations, traffickers, et cetera, that would be, quote unquote, revived under Senate Bill 201. Trafficking has been illegal in our state, and our current knowledge of trafficking today has more traditionally been seen as pimping, pandering, and prostitution, which again has always been illegal activity, and also has always been subject to negligence and intentional tort claims. So it is very unlikely that even if this was considered a substantive revival, that would be unconstitutional. It's probably very much constitutional. The second thing I wanted to mention is that floodgates of litigation. I always get questions about, well, what about the floodgates of litigation? We open up a window, look what happened in New York. They have the open windows for child sex abuse. They had tens of thousands. You see all these big headlines about it. Well, that's actually false and very misleading. Statistically speaking, there was a very insignificant increase in tort filings that we've seen in these civil statute of limitation revival windows. There have been 24 states that have passed revival windows between 2002 and 2021. Right now, there are 31 states that have revival windows going through the legislature, including states like Texas and Arkansas, South Carolina, so some of our similar states with similar commitments to anti-trafficking. Under the New York open window that was for 2 years, they saw a 1.33% increase in all civil tort filings during that period of time. And all of that increase cannot all be attributed to the open window cases. So I can't imagine that this bill would create a floodgate, especially because those bills I was mentioning before, the other revival windows we've seen, were specifically for child sexual abuse, which often does include child sex trafficking. We don't really know the scope of child sex abuse or trafficking, but we know 1 in 10 children are likely to be sexually abused under the age of 18. It's less for trafficking. So again, very unlikely that this would cause a floodgate. And I will leave it there, but really the bottom line here is that bills like this can be very, very therapeutic for survivors and are good for our community and our state. It provides deterrence against wrongdoing, especially when you're talking about businesses that know that trafficking is happening on their premises, and they are financially benefiting from these trafficking ventures. These types of laws can shift the costs. They can empower and heal survivors. It makes our state a safer place. We are putting our state and our citizens on notice of perpetration and where these activities are taking place. And I'm happy to answer any questions as to the effect of any of the portions of this bill.
Thank you, Mr. Hetherington, and appreciate your work. Any questions for the professor? Senator Hatchett.
Chairman, I just want to say thank you for coming and explaining this to us in more detail, and tell Kelly Casey I said hello. That's one of my favorite professors when I was in law school.
I don't know if you remember, I mooted you before you went.
I do. Okay, I remember now. Yeah.
Boy.
At the appropriate time, Mr.
Stopping
Chairman.
another joke I was going to make on you, but it's not the appropriate time yet. All right, thank you.
Okay.
Ms. Quinn, do you want to be heard before we have the appropriate time?
Yes, I will wrap us up.
All right, wrap us up.
My name is Amelia. I'm the executive director of Beloved Atlanta. It's a local nonprofit that provides residential homes and a 2-year restoration program for adult survivors of sex trafficking. While we work with women over the age of 18, the average age of our resident is mid-30s to mid-40s, and the vast majority were trafficked whenever they were children. So they are the exact population that is not benefiting from the current law. If we look at this population and see that they were trafficked as a child, what they're working to overcome is very limited education, very limited, if any, work experience, and decades of not being able to care for themselves from a mental health perspective, but also just from a physical perspective of not getting dental care, not getting medical care. And as we know, as those issues are not addressed, they become more and more a financial burden on us. So I think the question we're asking today is, what can we do to set up those who are overcoming extreme adverse circumstances to become full-fledged members of our society again? And a big part of that is financial stability, which they would be able to seek, and justice, knowing that those that played a part in their trauma and in their trafficking are being held responsible. I'll end with a quick story. I was talking to a woman this Friday who is a survivor of trafficking. She's graduated the Beloved program, and she just got a job that she's really excited about. She was going to start her job the next day, but a part of her car broke, and she didn't have the finances to fix her car. So she was driving around the city figuring out what she could do. She called Beloved, and Beloved was able to pay for that car part. But this would have given her the ability to become more financially stable and empower her to meet her own needs, which is a long-term goal that benefits our entire community. So thank y'all so much.
Thank you. Appreciate it, Ms. Quinn. Any questions for her? All right. Thank you. Thank you for the work that you do as well. All right. Everybody else signed up to speak on the bill. What's the pleasure of the committee? Senator Hatchett.
Thank you, Mr. Chairman. I'd like to make a motion to pass.
A motion to pass by committee substitute. A second from Senator Setzler.
I'd like to make a closing statement.
I'd like to.
Is there a motion to table it takes precedence over? Just kidding. Just kidding. All right. All those in favor of the motion, please raise your hand. By committee substitute. And you also have it unanimous.
Great.
Congratulations. Thanks for the work.
Thank you.
All right. With that, we are adjourned. Thank you.